committees. This, my lords, notwithstanding my own personal objection to transporting human beings for processing, which will no doubt be subject to further political and legal scrutiny in the months and years ahead. For present purposes, I take the government at its word, even if that word has been put rather belligerently both to the Supreme Court and to your Lordship's House. I will assume that the government does not want to put the executive of the United Kingdom on a collision course with our Supreme Court or our international legal obligations. So amendments in this group seek to offer a way through the stalemate for people of goodwill from all sides of your Lordship's House. Amendments 1, 2, 5 and 34 in my name are supported by the Most Reverend Primate, the Archbishop of Canterbury, and the Noble Lady Baroness Hale of Richmond, and by the Noble Viscount Hailsham. I have also signed the Noble Viscount Hailsham's Amendments 3 and 7. Lord Jermyn has Amendments 11 and 12. Your Lordship's Constitution Committee warned of a number of concerning trends in the present government's approach to our Constitution and our courts. It seeks, for example, to disapply the Human Rights Act for particular unpopular groups rather than repeal it wholesale for everyone. However, my lords, I observe another new fashion in adding a lengthy introduction to a relatively short bill that deems facts changed, making its purposes so clear that the courts should be wary of interpreting the legislation as they might otherwise do. However, since the arrival of this bill in your Lordship's House, the Prime Minister has stated, by a press conference, but he has stated that his Rwanda bill was designed to assuage the concerns of the Supreme Court. So, Amendments 1 and 2 add a secondary but essential purpose to the primary purpose of preventing and deterring what the government sees as unlawful migration. This purpose is to ensure compliance with the domestic and international rule of law by providing that no one will be removed to Rwanda unless two conditions are met. The first condition is that there is advice from the UNHCR that Rwanda is now safe. For example, as a result of the successful implementation of promised reforms and safeguards to the asylum system there. The second condition, my lords, is that this advice has been laid before both Houses of Parliament. Now, some may balk at what they regard as a foreign body having any role whatsoever in the assessment of facts on the ground in Rwanda. However, as the Joint Committee on Human Rights noted, our Supreme Court's concerns about the lack of safety there were in no small part in the light of unequivocal expert evidence from the UN High Commissioner for Refugees, with its special expertise and role under the Refugee Convention. If the executive is now asking Parliament to become complicit in overturning findings of fact by our Supreme Court, this made explicit by the Noble Viscount Hailsham's Amendments 3 and 4, it should at the very least, my lords, allow Parliament to hear advice from the expert body that the Supreme Court found so authoritative before allowing facts to be deemed as having changed. Accordingly, my lords, Amendment 5 replaces the edict that Rwanda is safe with the belief that it may become so, because it should be our unanimous aspiration that the whole world becomes a safer place for persecuted and displaced people. Further, my lords, as even an independent expert body should never usurp the fact-finding jurisdiction of our courts, especially in dangerous and fast-changing times, Amendment 34 makes clear that even clear and positive advice from the UNHCR would create only a rebuttable presumption that Rwanda is safe, in keeping with earlier legislation as observed by the Constitution Committee of your Lordship's House. It would not hobble our courts with an absolute conclusion. Yet, my lords, if the government is really so confident that the Rwanda Treaty, unlike the Refugee Convention so long before it, will be implemented so as convincingly to render that country safe, the government has nothing to fear from either these amendments or our courts. I beg to move.
Amendment proposed. In clause 1, page 1, line 2, after the, insert the word first. The question is that this amendment be agreed to.
I must begin by apologising for the fact that I was abroad at the time of second reading and was therefore not in my place at that time. My Lords, much was made at second reading of the notion that the bill in some way contravenes our constitutional principles, is an affront to the separation of powers, and infringes on the power of the judiciary. I think those allegations are thoroughly misconceived, but they are highly relevant to this amendment. The plain fact is that we are a parliamentary democracy. That means that Parliament is sovereign. And the reason why so many of us cherish that overarching principle is that we attach high importance to something called accountability. Accountability, my lords, was not a word which featured very large in your lordship's debate on second reading. The courts are accountable to no one. They proudly proclaim that fact. Many of the bodies to which Parliament has in recent years outsourced some of its responsibilities have little, if any, accountability. But Parliament itself, or at least the other place, the House of Commons, in which I was privileged to serve for 27 years, is truly accountable. It is answerable to the British people at regular intervals, and its members can be summarily dismissed. There are those who seem uncomfortable with our system, and it is indeed true that there has been something of a whittling away at it in recent years. The courts have extended their power, and Parliament itself has contributed to it by the outsourcing to which I've referred. I often think it's a pity that those who praise these developments fail to come up with some suggested alternatives to parliamentary democracy, but there it is. These amendments, if passed, would mark a new jump in this process. I would like to ask those who support it to address the question of accountability. To whom is the United Nations Commissioner for High Refugees accountable? Perhaps they might say to the General Assembly of the United Nations. To whom is that body accountable? Neither the High Commissioner nor the General Assembly have any responsibility for securing our borders. They have no responsibility for the safety of those who make the perilous channel crossing. They have no duty to take into account the resentment felt by so many against the sheer unfairness of illegal immigration and the way in which it gives preference not to the most deserving, but merely to those who can afford to pay the people's surplus. Our elected government and this Parliament do bear those responsibilities, and the House of Commons is directly accountable to the electorate for the way in which those responsibilities are discharged. These amendments would prevent our government and Parliament from discharging those responsibilities. They seek to outsource those responsibilities to an unelected body with no accountability. The acceptance of these amendments would constitute nothing less than an abdication of the responsibilities of government. I note without surprise, of course I give rise to
I'm most grateful to the noble and learned Lord. I don't understand the argument he's making. As I understand the amendment in the name of the noble learned Baroness Chakrabarty, the responsibility laid on the UN High Commissioner for Refugees would be to advise the Secretary of State. I don't see how that makes him accountable. It would remain the Secretary of State, surely, who was accountable to this Parliament for the decisions he decided to take in the light of the advice he received.
Well, I fear not. The easiest way of replying to the noble lord is to read from the members' explanatory statement of the amendment. This is what they say. The amendments require positive UNHCR advice on the safety of Rwanda to be laid before Parliament before claims for asylum in the UK may be processed in Rwanda. So if there is no positive advice from the UNHCR, those claims cannot be processed in Rwanda. I hope that aids the noble lord's understanding of what I'm saying.
I'm grateful again to the noble lord. I was referring to the text of the amendment.
Well, I think it's perfectly reasonable if one looks at one wants to know what the intention of the amendment is, to look at the member's explanatory statement of that amendment. That is indeed the purpose of the explanatory statement. Lords, I note with interest, but not with surprise, that none of these amendments are signed by any member of the opposition front bench. I'm not surprised, because no party which aspires to government could support the abdication of the responsibilities of government which these amendments would achieve. Before I sit down, I just want to say one word about Amendment 7, which is in the name of my noble friend Viscount Hailsham and others. Amendment 7 asserts that the decision of the Supreme Court was a finding of fact. But the decision of the Supreme Court was not a finding of fact. It was a finding of opinion. The Supreme Court's opinion that the removal of asylum seekers to Rwanda would expose them to the risk of refoulement. It is an opinion on which men of good faith and true can disagree. Indeed, it is an opinion on which distinguished judges disagreed. The Divisional Court, one of whose two members was a Lord Justice of Appeal, came to the conclusion that what the government was proposing to do was entirely lawful. The Court of Appeal, by a majority, disagreed, but the then Lord Chief Justice dissented. So, in my view, when the Supreme Court reaches a conclusion on a matter of opinion, it is entirely legitimate and entirely proper constitutionally for Parliament, democratically accountable to the House, to the people, as the House of Commons is, and the Supreme Court is not, entirely proper for Parliament to substitute its own opinion. That is what this bill does, and that is why I support it.
My Lord, I rise to speak very briefly in support of Baroness Chakrabarty. I just want to put on record for this House that the Bar Council has a real concern about the apparent incompatibility between the European Convention for Human Rights and this bill. The Supreme Court, as we know, made a decision, in my view, on the basis of facts, that Rwanda is not a safe country. And they put a whole series of points to support that view. This bill has not in any way countered any of the points made by the Supreme Court in their judgment, and the Bar Council is concerned about that. The Bar Council is also concerned that the government is standing down the judges from their role as overseeing the work of the government in operating this bill. And the Bar Council see this as a clear infringement of the fundamental principles of the rule of law. That in disapplying, in this context, the Refugee Convention on Human...
Isn't it right that Clause 4 of the bill provides exclusively that members of the judiciary will have the opportunity to consider challenges brought of an individual nature in relation to particular claimants?
My lords, that may be so, but I think the point I made stands, and I think perhaps I've said enough to point out that the Bar Council has very real concerns about this bill.
It is... Please.
My Lords, I will speak mainly to Amendments 11 and 12 in the name of my noble friend, Lord German. I can't stop myself saying that it really goes against the grain to do anything which suggests that Liberal Democrats regard the bill as requiring only some tweaking for it to be acceptable. But I'd like first to make a general comment about Clause 1. For many years, governments, plural, have opposed amendments setting out the general purpose of a bill on the basis of a clause having no effect and being rather confusing. And I used to find that understandable, though I signed some such amendments. They've tended to be narratives describing hopes rather than expectations or anything firmer than that. The noble Baroness Chakrabarti has commented on the changing fashion, them being there to make the courts wary of the direction in which they might like to go. But I think that this problem applies to Clause 1, and I would note that there is a notable omission from the exposition of the government's policy, and that is tackling people smuggling, abhorrent in itself, not only because of the smugglers' role in bringing asylum seekers to the UK. The Illegal Migration Act has a similar introductory clause, but specifically it says in section 1(3), accordingly, and so far as it's possible to do so, provision made by or by virtue of this Act must be read and given effect so as to achieve the purpose mentioned in subsection 1. So I believe it's important to be clear about the effect of Clause 1, the legal effect, that is. If it is intended that the clause is to be relied on, then I think it needs to be sharpened up. For instance, terminology such as the system for processing claims is to be improved, an objective of the treaty, which is a pretty low bar. But my central point is that we need to be very clear about the legal effect and status of this clause, because there'll be little point in amending the clause at report unless the amendment has an effect, either as a standalone or by subsequent reference, such as the Act not coming into force unless a provision in Clause 1 is met. This may seem a rather technical point, but looking ahead, I don't want to be tripped up on it. Amendment 12, and I'm aware it's an amendment to the clause whose effect I've been querying, is therefore a probing amendment. and it's an amendment to the definition of a safe country. It includes in 15b little 2 a determination of being treated in accordance with that country's, i.e. Rwanda's, obligations under international law, and the amendment would change that to being in accordance with the UK's obligations under international law. The treaty is predicated on Rwanda being under the same obligations and as observant of them as is the UK, so that the transfer to Rwanda, as I understand it, means really only a change of venue. Dr. Google didn't really help me yesterday in finding what conventions Rwanda has signed up to and, importantly, ratified and observed. But since we are proceeding on this on the basis that everything that we would do in this country will apply under the new regime, I'd be interested in the Minister's comments. Amendment 11 is related to this, Clause 15A, which also defines safe country for the purpose of the bill. It includes or refers to the UK's obligations that are relevant to the treatment in that country of persons who are removed there. Surely, my lords, it's all obligations relevant to treatment of persons removed there, not just in that country. So both amendments go to the issue of safety. That is the bill's compatibility with the UK's human rights obligations, and it's the UK's human rights obligations that are crucial as part of this whole regime.
It is a hard act to follow, so many lawyers here, and I hope that my compassion and conviction might help me where I'm missing in legal expertise myself. My lords, I support the amendments to Clause 1 in the name of the noble Baroness Lady Chakrabarti, which introduce an additional purpose of compliance with the rule of law and the role of the United Nations High Commissioner for Refugees. I apologise I was unable to join your lordships for second reading as I was overseas. I have read the Hansard record of the debate, during which many noble lords raised what I see as the fundamental issue at stake with this bill and the Rwanda scheme more broadly, how it is squared with the rule of law, with the international agreements and obligations which are the bedrock and defence of our freedom and prosperity. My lords, I come to this with a conviction that our best chance of solving the global challenges we face, illegal migration among them, is not through unilateral action, but through international cooperation and by standing up to the rule of law. Other noble lords have explained how these amendments would help ensure that refugees really are safe, and that the importance of this as a matter of humanity as well as of law. I suggest that recognising a role for UNHCR is also important from an international perspective, and as a route towards a lasting solution the government seek. It is right to want to reduce people smuggling, but if this bill is to have a positive impact, it will only be as a part of a wider approach. The preamble of the 1951 Refugee Convention is surely correct when it states that a satisfactory solution to the problem of supporting refugees in a fair and humane manner without placing an undue burden on any state cannot be achieved without international cooperation, and notes that the effective coordination of measures taken to deal with this problem will depend upon the cooperation of states with the High Commissioner. As I have argued in your Lordship House before, a lack of respect for international law and the weakness of international institutions lies behind the larger number of people forcibly displaced around the world. While not the only cause, wars of aggression, indiscriminate or deliberate targeting of civilians, war crimes and crimes against humanity drive displacement. We will not reduce the number of displaced persons globally while wars and atrocities continue unchecked and while international law is applied unevenly. At a time when we and the wider West are struggling to maintain any credibility when it comes to the rule of law and international cooperation, recognizing in law a place for UNHCR is determining the safety of the Rwanda scheme would be a small step towards demonstrating our ongoing commitment to international institutions and agreements which are critical to global security. My Lords, it has become a bit of a trope to say that the Refugee Convention and UNHCR itself are outdated and unable to rise to the magnitude of the task at hand. In supporting a role for UNHCR in this legislation, I would challenge that view. It is worth putting the scale of the refugee situation in some context. As a recent book, How Migration Really Works, by Professor Hein de Haas, one of the world's leading experts on migration, sets out very clearly, current refugee numbers are not in fact exceptional or unprecedented. There are 30 million refugees globally, but this is 0.3% of the global population, only marginally above the proportion of refugees in 1992. The vast majority of displaced either stay in their country of origin or their immediate region. It is a small minority who come to Europe and to the United Kingdom. This is a challenge that we should be able to rise to. The refugee crisis is one of the protection and political will, not only sheer numbers. My Lords, this bill is all about signalling. The government hope to signal that they are tough on illegal migration and to deter small boat crossings. But we are at risk of signalling that we are uninterested in the rule of law and in our international agreements and cooperation. That would be a very serious mistake, whether for our ability to cooperate over refugees or on our other global issues and international rules-based order.
My Lords, I rise to support Amendment 1, tabled by Noble Baroness Chakrabarti, Baroness Hale of Richmond and the Most Reverend Primate, the Archbishop of Canterbury, and Amendments 2, 5 and 34, tabled by the same, to which is also added the name of the Viscount Hailsham. I also wish to offer supportive comments on Amendment 7 to Clause 1 in the bill, tabled by the Noble Lord Viscount Hailsham, the Noble Baroness Baroness Chakrabarti, and the Right Reverend Prelate the Bishop of Manchester. The Lord Archbishop of Canterbury is present, but is unable to attend the entirety of this debate. The Lord Bishop of Manchester is unable to be with us this afternoon. My Lords, it will be a very slight augmentation to the wisdom of this House to know that we on these benches do not favour the outsourcing of asylum claims to other countries or territories. This is rather different to what the Noble Lord, Lord Howard, was saying about the outsourcing of power. We do recognise, however, that the courts have deemed this lawful in certain circumstances, designed to deal with a particular designation which the Supreme Court deemed to fall outside our own obligations under the law. I accept, my Lords, that the recent treaty between His Majesty's Government and the Republic of Rwanda makes legally binding, and with additional enhancements, the Memorandum of Understanding between the two governments of 2022. For example, the undertaking that under the new asylum procedure, there is a commitment that no person relocated under the treaty to Rwanda will be sent to any country other than the UK, if the UK so requests. However, as the House knows, the International Agreements Committee of this House does not recommend ratification until further evidence is available. Nonetheless, my Lords, there remain very significant concerns about the contents of the bill as it currently stands, not least using legislation to make a declaration of fact in order to correct a court which has heard evidence. It is clear, my Lords, that the government has gone to a great deal of effort in order to provide evidence to persuade critics of the feasibility of removal to Rwanda as a safety and properly functioning process, while at the same time trying to satisfy its policy aim and critics of a different stamp, that the limited capacity of this scheme will be a deterrent to those who make long and dangerous journeys in order to cross the Channel. The purpose of these amendments is, I believe, to match the bill more closely to the requirements of the Supreme Court judgment, and thus both more just and less open to challenge. My Lords, for the sake of the people whose lives will be affected by yet more upheaval, who as it stands will not even have the opportunity to have their claim heard in this country, we cannot afford to get this wrong. Courts and tribunals must be able to make a judgment about the safety of Rwanda based on a consideration of the facts. We are not primarily discussing the suitability of Rwanda, we are discussing its safety for people who, by definition, have highly complex lives and circumstances. The treaty introduces safeguards and checks, so it should, but these are not yet in force. I share the view, my Lords, that more is needed. The United Nations High Commissioner for Refugees, an agency with which the government has worked with in a highly effective way over many years, should provide that positive judgment of safety. Until then, the government is taking an unreasonable risk by sending anyone to Rwanda. These amendments, my Lord, offer practical steps which strike a kind of balance we are wise to pursue in this revising chamber. They do not wreck the bill, nor remove the objective of deterrence from it, though we can debate in due course the degree of inhibition it brings into the process. Rather, these amendments, my Lords, provide an adequate mechanism for addressing concerns about the UK's compliance with international law, and appropriately given the name of this bill, the safety of Rwanda as a destination for the processing for asylum claims intended originally for the UK. These amendments, my Lords, are important for the preservation of judicial oversight and for the maintenance of the separation of powers, which is a fundamental component of our Constitution. It is for Parliament to make laws, it is for the judiciary to judge cases, including the lawfulness of government decisions, and to make findings grounded on the basis of evidence. Amendment 7, my Lord, seeks to make it plain that the bill before us replaces the Supreme Court's finding of fact. My Lords, a bill cannot change the actual situation on the ground in another country. It can only mandate that evidence to the contrary. That is disregarded. We have a duty of care in international law towards asylum seekers who arrive in this country. Legislating, my Lords, that Rwanda is a safe country does not necessarily make it so for the potentially vulnerable people who might be sent there. This amendment seeks to make it plain that the bill before us today replaces the Supreme Court's finding of fact. The bill's primary purpose is to disregard the UK's own Supreme Court's finding that Rwanda is not a safe country for asylum seekers. A bill cannot change the actual situation on the ground in another country. It can only mandate that evidence to the contrary is disregarded. We have a duty of care towards asylum seekers who arrive in this country. Legislating that Rwanda is a safe country does not necessarily make it so for the potentially vulnerable people there. Let us be clear, my Lords, what it is we are doing. The Law Society have said unequivocally that it is inappropriate for the government to undermine the judiciary in this way, and that the bill threatens the balance of powers in the United Kingdom. This amendment would put onto the face of the bill that a judicial finding of fact is being replaced. I hope, my Lords, that we give these amendments a fair wind.
My support to the amendments in the name of the Noble Baroness Chakrabarti, the Most Reverend Primate, and the Most Noble Lady Baroness Hale. And in doing so, to express some slight puzzlement that the government seems to have difficulty in accepting these amendments. The government tells us again and again that nothing in this bill is contrary to our international obligations. Okay, well then just accept these amendments and make that even clearer than it was before. One may have one's doubts. I would like to address one or two of the points made by the noble and learned Lord Howard, because they were extremely far-reaching and, I would say, very, very damaging and disruptive of our ability to support a rules-based international order. Because he seemed to not take into account that it was this sovereign parliament that ratified our membership of the United Nations in 1945. And that Charter of the United Nations contains the Charter for the General Assembly, and the General Assembly appoints the High Commissioner for Refugees. So I don't think his argument about lack of accountability stands up. But also, if you think about it, in contradicting any role for the High Commission for Refugees to give advice to us about whether or not Rwanda is a safe place is an extraordinarily far-reaching and damaging claim to make. Because if they...
It's not, as I said in answer to Noble Lord Fair, it's not simply a question of seeking advice from the United Nations High Commissioner. The amendments clearly state that unless positive advice is obtained, no one can be removed to Rwanda. So the decision will no longer be the decision of the Secretary of State, it will be the decision of the United Nations Commissioner for Refugees. That is the point. It's not just advice, it's advice which would be binding, according to these amendments, on the government.
I thank the noble lord for that point, which interrupted me before I got to the answer to his question. That is fine. What I had been going to say was that the doctrine, according to the noble Lord and learned Lord Howard, is that every member that has signed the Refugee Convention, well over 150, I think, and ratified it, including our sovereign parliament, has the right to reinterpret the convention as it wishes. Now, you only have to, for 1 minute, stop and think what that implies to realize that it implies complete chaos and the law of the jungle. If all 150 members of the United Nations Refugee Convention, 150 plus, are able to stand up and say, well, actually, this is what I think the convention means, and I don't care a damn what the High Commissioner for Refugees says, then we are living in chaos. And it's to avoid that these amendments are being put forward, and I do strongly support the arguments of the noble Lady Baroness Hellich, who seemed to me to express extremely eloquently the reason why this country has a real interest in paying attention to these matters. Yes?
For giving way. I thought it might help the committee for me, before this debate with the noble Lord Howard rumbles on, to clarify that he is quite right, that this amendment, as currently drafted, requires positive advice from the UNHCR, not just advice, positive or negative. Now, the reason for that, in the current iteration of the amendment, is that the Prime Minister expressly said that this bill is designed to assuage the concerns of the Supreme Court, and they were based predominantly on the negative advice from the UNHCR about the situation in Rwanda. Such was the nature of the evidence of UNHCR and the credence that our Supreme Court gave to that evidence. However, the noble Lord Howard of Lympne, or indeed the government, are welcome, if that formulation is too rich for their blood, they are welcome to amend the amendment or offer their own, which requires only advice, positive or negative, by the UNHCR before either the Secretary of State or indeed Parliament can look again at whether Rwanda has changed subsequent to the treaty and is now or in the future a safe place for asylum seekers and refugees.
Don't wish to pursue that course at all. I'm not one of the proposers of this amendment. I'm merely supporting it. But the arguments that I'm adducing are arguments that relate to the state that this country would be in if it issues forth into the world and says it has an absolute right to interpret a United Nations convention which it ratified many years ago and which it has supported through thick and thin ever since, and now wishes to contradict. And that is a serious matter, and I do not believe myself that the noble Lord Howard's arguments ought to carry weight, because I think the implications of them for our position in the world and our support for a rules-based international order would be extremely damaging.
And very friend. My Lords, I want simply to say a few words in support of Amendment 3 and 7, which are in my name, and also to express some more general support for the position adopted by the noble Baroness Chakrabarty. As regards Amendment 3, it is simply untrue to state that it is the judgment of Parliament that Rwanda the elective dictatorship of which my father spoke. But what is absolutely certain is that it is not the opinion of this House. And we know that to be a fact because of the vote that took place on the 22nd of January in this House. In my opinion, we should not put onto the face of a bill a statement which is manifestly untrue, and hence why I have put down amendments which state the truth. And the truth is that the safety of Rwanda is the opinion of the government. That is the truth. And why on earth should we not enact that simple truth, rather than commit what in other circumstances would be described as a lie? As regards Amendment 7, we should state in clear terms what we are doing. We are, in fact, using a statutory and untrue pronouncement to reverse a recent finding by the Supreme Court. My learned friend, Lord Howard, for whom I've had the greatest respect, we were colleagues for very, very years. He was in the House of Commons for 27 years. I beat him. I was there for 30 years. But he was a lot more distinguished than I was. But to try and say of the House of Law, of the Supreme Court, that they didn't make a finding of fact is to turn a situation on its head. They expressed an opinion as to fact, as juries do in criminal cases. And an opinion as to fact is a finding of fact. Now, I'd like, if I might, to take a little broader view. I happen to share the view, and I suspect it's pretty general in this House, that both legal and illegal migration is far too high and should be reduced. I share the very correct intention of the government that we need to deter illegal migration. My objection is not to the purpose, but to the means which is being advocated, which is, in my view, wrong in principle and will not succeed. However, it is clear to me, as it is clear to the Baroness Chakrabarty, that the government decides to push ahead and will doubtless, in ping-pong, reverse our amendments. But in the spirit of compromise, as did the Baroness, I would like to make some positive suggestions. Leaving aside the issue of principle, I'm concerned that the government is seeking to enact, without any proper assessment, its judgment as to whether Rwanda is safe. And that means not just whether the treaty is put into place within Rwanda, but also whether the provisions of the treaty over a period of time are implemented. And also, not just that, but also whether for other reasons we can say that Rwanda is safe. That we are entitled to do. And be clear about it, that is not a one-off assessment. That has to be a continuing assessment, because things can change. And the other thing we need to be absolutely clear about is whether the policy objective is working. We are told that the purpose of the bill is to reduce illegal migration across the Channel. That is a judgment. I don't happen to think it'll work. But one thing is certain, is that we don't know whether it will work now. But in the course of time, we may be able to form a view as to that. So my concern is that the bill provides no mechanism for a continuing assessment, both as to the safety of Rwanda and as to the success of the policy. And I believe that Parliament is entitled to demand a continuous and authoritative assessment. Now, we could argue whether it should be based on the European body, or whether, as Amendment 81 suggests, the Joint Committee of Human Rights, or as I've in the past suggested, a special joint committee, select committee appointed for the purpose. But there is a way forward, which is this. This bill does not come into operation without both houses of Parliament, by an affirmative resolution, triggering it. And they can only trigger it once a report has been received from whatever assessment monitoring board we put into place. And that is not enough, because, as I say, what we need is continuing assessment. So what I contemplate is something like this, that the initial trigger should be, say, for 2 years. It could then be renewed by another statutory process, affirmative resolution, on the basis of a further report, renewed for 2 years. And then again, if the Secretary of State thinks he'll get away with it. But that way, we will have a continuing process of assessment. And that would give this House and Parliament in general something on which it could honourably proceed. And I would like to think that my noble friends on the front bench will show a certain degree of flexibility. Because if they don't, it may be quite difficult to persuade their critics to be flexible.
I briefly want to follow my noble friend Lord Helsham in his remarks. And had he been the presider in a three-man court or three-person court, I would have been very happy to say that I've heard his speech and have nothing else to add. But since we're here, you have the disadvantage. You have the disadvantage of hearing what I have to say. Like my noble friend Lord Howard of Lymm and my noble friend Lady Hellich, I regret I was not here at second reading, and I apologise, but I've read the Hansard of the debate. I'm always reluctant to disagree with my learned friend, my noble friend Lord Howard, but I think he took too narrow an approach to the questions before us. And I use clause 1(2) little b, which is the subject which my noble friend Lord Helsham attacks, as a hanger on which to make a few remarks. I think, if I understood him correctly, my noble friend Lord Howard said that Parliament can essentially do what it likes. And of course, he's perfectly right. Parliament can be as foolish as it likes. Parliament can pass a law saying that all dogs are cats, but it doesn't make all dogs cats. Parliament can pass a law saying that Rwanda is a safe country, but it doesn't make it a safe country. And this is where I agree with my learned friend, Lord Helsham. It's for the government, it's for the executive to advance its policy, whether it's a good policy or a bad policy, but it's for the government to say it is our political opinion or it is our policy that Rwanda is a safe country to which to return or to which to send failed asylum seekers. If the government then wishes to have its view tested by Parliament, well, again, it can go ahead and do it. So what the government is proposing as a matter of policy is not a constitutional outrage, but the way in which they are writing it down in Clause 1, Subclause 2, little b, is, if I may respectfully say so, just plain silly. And I think it is worse to be silly than it is to be guilty of a constitutional outrage. And this is not a constitutional outrage. It's just plain silly. And ridicule, if I may say so, is a more powerful weapon than the constitutional and legal arguments of any number of lawyers. It would, of course, as the noble lady, Lady Chakrabarti, advances in one of her amendments, it would, of course, be helpful to have a UNHCR opinion in favour of the safety or otherwise of Rwanda. But I have a feeling that exporting government policy to the UNHCR is not a good idea. It would be helpful to have that opinion, but it's not essential. And the government must stand on its own feet, bring its policy to Parliament, have it tested, and it will either survive or not, as the case may be, on the merits of the facts. But the assessment of whether Rwanda is a safe country is an assessment that must be for the government to be considered by and to be agreed with by Parliament, but we as a bicameral parliamentary body, I suggest, are not equipped to reach those sorts of conclusions. We can agree with, we can disagree with the government, but we are not equipped, it seems to me, in a presidium to reach a conclusion about whether, as a matter of fact, the Republic of Rwanda is a safe country. My Lord, I don't wish to undermine or underplay, or shall I say, underestimate the hugely difficult political problem that the government faces with illegal immigration and the making of unsound asylum applications. Nor do I wish to undermine their genuine and very proper decision and policy to stop the boats. But if we are to stop the boats, if we are to reduce the amount of illegal immigration and the amount of bogus asylum applications, may I suggest that the government would go a long way if it had the confidence of its own convictions and allowed clause 1, 2, little b, to say that the Act gives effect to the politically expedient policy of the government that the Republic of Rwanda is safe, rather than trying to shift the responsibility for that opinion upon Parliament. Parliament may come to agree with it, but the initial policy is one for government, and to that extent, I wholly agree with my noble friend, Lord Helsham.
Well, thank the noble Lord. I'm another supporter of Amendment 3. Clause 1 is an example, as it seems to me, of the current vogue for starting bills not with operative provisions, but with preambular statements of the obvious, a custom which is always irritating, but normally harmless. There is, however, harm, I suggest, and not just silliness, in Clause 1.2b, with its rather grand invocation of the judgment of Parliament that the Republic of Rwanda is a safe country. A judgment apparently for all time that there is no provision to revisit or to change. That invocation, I suggest, is both unnecessary and contrary to principle. It's unnecessary because there are other ways for Rwanda to be declared or deemed safe. The Secretary of State could be entrusted with the decision, or if it is really necessary for Parliament to take it, there could at least be a power in the Secretary of State to amend it in the light of changed conditions, as was the case in Section 7.5 of the Illegal Migration Act 2023. It's contrary to principle because it requires us to come to a judgment on a fact-specific, life-and-death matter on which we are frankly ill-equipped to adjudicate. Of course, this is not the first time such a thing has happened. It was tried in the Asylum and Immigration Act 2004, when the countries of the European Economic Area, all of course signatories to the ECHR, were deemed irrebuttably to be safe. That experiment, a requirement of European Union law, was not a successful one. Its unwieldiness was demonstrated in the case of Nasiri. The Judicial Committee of the House of Lords dismissed a challenge to the safety of Greece, but through, I believe, the noble and learned Lord Hoffman, who I am delighted to see in his place, indicated that the courts might have to issue a declaration of incompatibility in the event that the deeming provision was contradicted by the evidence. The issue was sensibly addressed in the Nationality and Borders Act 2022 by transforming the irrebuttable presumption into a rebuttable one. No such good sense is on display in Clause 1.2b, a much more contentious provision because of its very different context. It asks us to state definitively that Rwanda is safe when all the evidence points the other way. In particular, the verdict of our own Supreme Court, which identified defects that it did not consider solvable in the short term, and the judgment of our own International Agreements Committee, which we endorsed by a healthy majority when we voted on it on the 22nd of January. Of course, we can do anything we want, but this does not mean it's sensible to do so. As the Joint Committee on Human Rights put it in its report of this morning, the courts remain the most appropriate branch of the state to resolve contested issues of fact. And a unanimous Constitution Committee, on which I serve, went a little further last week, describing this clause as constitutionally inappropriate and invoking both the rule of law and the separation of powers. I emphasise the practical point that this clause puts Parliament on a quite unnecessary collision course with the courts, both domestic and international. Amendment 3 would not solve all the bill's problems. It would not even stop Clause 1 from being pointless, but it would at least render it harmless, and that is why I support it.
My Lords, like other noble Lords, I was unable to be present last week for the second reading, but I cannot allow this bill to pass through the House without making my very deep concern about its public and evident. And so I'm speaking first on this group of amendments because they go to the heart of my concern. I've been a member of Parliament for a very long time, on and off, and I've been a member of the Conservative Party for some 66 years, when I counted it up. And I do have to say that I find it quite extraordinary that the party of Margaret Thatcher should be introducing a bill of this kind. Like some other noble lords, I have a very clear memory of the great battle that Margaret Thatcher fought with the European Union, the community in those days, over the British budget contribution. And it was from time to time suggested in those days that she should cut the cattle and put the Continentals in their place and cut off the British contribution. And that would, of course, have been a very dramatic thing to do and would have been very popular in some circles. But she didn't countenance that idea because she believed that it would be contrary to the law. and there were those who warned that it might indeed even run into trouble in the British courts. Now, how different that is from this bill, how different that is from the way in which we are now being asked to behave towards the Supreme Court and towards the European Convention on Human Rights. And this is no esoteric matter that only concerns the subject under discussion and is only of interest to lawyers. We in this country boast frequently that Britain is such a marvellous place to do business because of our great respect for the rule of law, and that we're a great place to do business because the government, unlike some governments in the world, can be relied upon not to take arbitrary and unreasonable acts. Now, I think it's very difficult to sustain that argument in the light of the bill now before us, and I don't know whether those who are envisaging doing business in this country will draw that conclusion or not, but it does seem to me that we are going against a fundamental interest, not just in terms of this issue, but in terms of our wider reputation. What we're being asked to do really represents the sort of behaviour, my lords, that the world associates with despots and autocracies, not with an established democracy, not with the mother of parliaments. It is a bill we should not even be asked to confront, let alone pass.
I'm privileged to follow what the Noble Lord Tugendhat has said, and I strongly agree with what he has said. I would just like to focus on two particular things in relation to what the government is asking us to do. But before that, could I apologise for not being here at the second reading? I too was abroad, and can I declare an interest that I'm a member of the Constitution Committee of this House, which published a report that expressed very considerable concerns unanimously about this bill. I have two particular concerns about this bill. We as a nation, for the last 70 years, have accepted that we will not deport asylum seekers to a place where they may face death, torture, or inhuman treatment. And if asylum seekers feel that that is a risk, they can seek protection from the courts. And the courts may well give an applicant short shrift if they don't think there's anything in it. But that protection we have stood by for 70 years and incorporated into our domestic law in the Human Rights Act 1998. This bill envisages the possibility, indeed those who have looked at it independently, the more likely than not result, that people will be sent to Rwanda where they will be at very substantial risk of then being refouled, which means sent back to a place where they could be tortured or killed. The answer that the government gives is, oh, we've entered into an agreement with Rwanda that says they won't send anybody who comes from here to anywhere except the UK if they go to Rwanda. To which the answer is that given by the International Treaties Committee, which says the reason there was a risk of refoulement, being sent to a place where you could be tortured or killed, was because Rwanda did not even have the most basic system of properly assessing asylum claims, and it was because they didn't have that system that the risk of refoulement occurred. The idea, as this bill envisages, that it comes into force the moment the new treaty comes into force, will provide the protection, is absolute nonsense. And everybody appreciates that, except as far as I can see, the Right Honourable Mr. James Cleverly, who is the Secretary of State for Home Affairs. It's just a non-starter, factually, if you look at the conclusions that the Supreme Court introduced. Now, this government says, and I'm sure the noble Lord Sharp will confirm, that he stands by, on behalf of the government, the commitment that we've made for the last 70 years that asylum seekers will not be exported to a place where they might be refooled. If that is the true position of the government, how on earth can they be allowing this? I should also point out that the International Treaties Committee of this House said quite separately from the fact that you need to reform completely the asylum system in Rwanda, you've also got to enter into a number of other detailed provisions before it can be seen whether or not that provision in the new agreement prevents refoulement. And those agreements have not yet been entered into with Rwanda, and there's no requirement for them to be entered into before it becomes law. So my first big objection to this bill is that it goes against commitments we have made as a nation and stand by for the last 70 years. And if we are looking for solutions to the problems of immigration in the world, the idea of turning our back on all these international agreements we've made seems a very, very bad. My second big objection to this bill is that it fundamentally crosses over the separation of powers. The noble Lord Howard of Limp, who I greatly admire, who was a member of our Constitution Committee, said, "Oh, don't worry, we're just taking the opinion of the former Lord Chief Justice, who was the dissenting voice in the Court of Appeal." No, that is not what the government says they are doing. What the government says that they are doing is, well, we've taken account of what the Supreme Court judgment is. We respect that judgment. We're not going with the former Lord Chief Justice's judgment. We're dealing with the points that have been made. And by the way, dealing with them, we're not letting anybody question us about that, which is absolutely not the role of this House or the courts. What this bill leads to is Parliament delivering, the noble Lord Garnier describes it as silly. It is so much more profound than silly. I quite agree with you. The beginning of this bill is very silly in the way that it reads. It's a sort of cack-handed attempt to deliver a sort of judgment like a court would read. But it's not silly, it's dangerous. Think of 3 examples. First of all, this, whereby Parliament can say, even though we see Rwanda refouling people that we are sending, and they are sending Afghans and Syrians and Iraqis back to death or torture, we do nothing. We say that's okay because we made our judgment it was a safe country. That is one example. Take another example. Suppose the Prime Minister has a friend or a crony in the House of Commons who's convicted in a court of corruption of some sort. And then the Prime Minister presents a bill to Parliament saying it is the judgment of Parliament that Sunak MP actually wasn't able to present this new evidence to the criminal court that convicted him. So it is the judgment of Parliament that Sunak MP is innocent, because that is the route that this particular bill takes Parliament down. Take a third example, the Electoral Commission. The Electoral Commission decides that it won't investigate some particular problem of, say, not complying with expenses views, and then the court say, in relation to that decision, the Electoral Commission was over-influenced by party political considerations. For example, the governing party was very unkeen for there to be a proper investigation of some expenses fraud in an election. And on a judicial review, the Electoral Commission's refusal to investigate was set aside on the basis there was no basis not to investigate. Once again, relying on this precedent, the government of the day, assume it's got a big majority, produces a bill that says it is the judgment of Parliament that the courts have got that opinion, as the noble Lord Howard of Limp introducing a whole new concept in the law, says is the position. This is what the danger of this bill is. I'm not sure I support all of my noble friend Baroness Chakrabarty's solutions, in particular a reference to the United Nations Commissioner on Refugees as the right source. But my goodness me, if you start letting Parliament make those sort of judgments, you open a door that it will be incredibly difficult to close. And in this House, we should surely give effect to this. Just one final point. Lord Murray of the noble Lord Murray of Lidworth said, "Oh no, don't worry, it's all Section 4. It is not Section 4. Section 4 only allows appeals to be made by people who are saying something different from the country is not safe generally. It is only if there is something specific about them. So if, for example, I am a voluble member of the Rwandan opposition and I am then sent to Rwanda where I may get tortured or killed, then I've got a ground. But if I'm saying I'm from Syria or Afghanistan and they're refouling regularly, I have no basis for appealing. So stand by our commitments to asylum seekers is my first point. And my second point is, do not listen to this siren song that this is not a fundamental change in our constitution. It is, and it will be the foundation of very bad things to come.
My Lords, I was at second reading. I don't know if that makes me less interesting to listen to than the noble Lord Faulkner and all the rest. I have heard some of these remarks before, of course, but it's always a pleasure to hear them again if I agree with them. I am going to say something quite similar to what you've just heard from the noble and learned Lord Faulkner, but I will say it less competently, obviously, because I don't have legal training, but what I do have is common sense. I'm not suggesting they're mutually exclusive, obviously, but I would say they are two completely different things. And I'm arguing that this is an absurd bill. It is nasty, it's inhumane, and I don't want any part of it. And Greens have made it clear, along with our friends on this occasion, the Lib Dems, that we would stop it if we possibly could. So in line with that, I do support Amendment 3 in the name of the Noble Viscount Lord Hailsham and the Noble Lady Chakrabarty. And I think it was referred to that the silly wasn't an appropriate, it's frankly silly drafting. Clause 1(2)(b), that this Act gives effect to the judgment of Parliament that the Republic of Rwanda is a safe country. Acts of Parliament are not vehicles for Parliament to express its opinion about issues, so this clause ought to be removed on that basis alone, or else we start legislating opinions instead of laws. But Parliament is not of the opinion that Rwanda is a safe country. We haven't been presented with any evidence to prove that, and we've got no process to make such determinations. The best we have is a debate on amendments in this way, which we may pass and return to the Commons, or to the other end, or whatever you call it. The other end will, of course, the government will, of course, disagree with any amendments that we pass. They will almost certainly strip them out. And we will be back here debating again, wasting long hours in trying to make this government see sense. This is bad lawmaking and a silly precedent. Isn't a motion rather than legislation the correct vehicle for each House to formulate their judgment and express their view on an issue independent of one another? What future opinions will be voiced in legislation? What views will be forced on your Lordship's House by the elected House, no matter how wrong or how wicked? This deals with just one small part of this awful, awful bill, but it is illustrative of the constitutional and moral nonsense that runs throughout. This bill cannot be amended. It must be stopped. And in answer to the noble and learned Lord Howard, what we're trying to do with these amendments is to stop the government forcing us to lie. That's what we're trying to do.
My Lords, it's a pleasure to follow the noble Baroness Lady Jones. I have the privilege of serving as a crossbench member of the
Joint Committee on Human Rights, which was referred to by the Noble Baroness Lady Chakrabarti during her remarks, and indeed she referred to the 50-page report that was finally agreed by a majority in the committee. It's a majority, not unanimous report, on February the 7th, and as others have said, it was published today and is available in the printed paper office. I'll say, if I may, in my remarks, something about what it has to say about safety. But first, before doing that, I'd like to agree particularly with the tone of many of the contributions that have been made so far on this group of amendments. My noble friend Lord Hannay, as always, put his finger on our international obligations, not least amongst which is the 1951 Convention on Refugees. Now, it may well be, but this isn't written in stone, that there should be attempts to try and change and reform this in the climate of today's demands. I'll happily give way.
The noble Lord Alton for giving way, and he has just referred to international agreements. Would he agree with me, therefore, that this bill contravenes international agreements like the UNHCR, but also the ECHR? And I am reminded of the fact that the provisions of this bill extend to Northern Ireland, and hence this provision and this bill undermines the very basis of the Good Friday Agreement.
Well, I'm very grateful to the Noble Baroness. I wasn't intending to touch on Northern Ireland, but the Noble Baroness, Rishi of Downpatrick, is right that this does touch on the Windsor Agreement and on our obligations to Northern Ireland, which are separate from those of the rest of the United Kingdom. And I would commend that section of the report, not my opinions, but the report does touch on that question. But she also asks about our other obligations. There are many obligations that we have, not just in the Refugee Convention, but the ECHR she's just referred to, and yes, we have obligations there too. And of course, the government on this bill, as on the illegal migration bill, declined to give it a compatibility statement because the government itself cannot say that it will be compatible, although ministers I know take a contrary view that there is uncertainty around that. But if there's uncertainty, then one must be very careful where we tread. I was very struck, though, on the issue of our international reputation by the statement that was made by the former Pakistan Prime Minister, and which is referred to in the JCHR report, who justified what he was intending and has done in sending back 430,000 Afghan refugees to Pakistan. He said it was modelled on what we were seeking to do here in the British Parliament. So even though we know that that's casuistry, it's extreme, nevertheless we can see where this argument can lead and the way in which it can be used. So yes, our international reputation, as the noble Lord Hannay said, he is right to say that it can very easily suffer. The Right Reverend Prelate, the Bishop of Southwark, was, I thought, also got to the heart of this when he said that legislating that Rwanda is safe doesn't make it so, and the noble and learned Lord Faulkner of Horton touched on that same point. Just saying that an apple is a pear doesn't make it such. Saying that a dog is a cat doesn't make it such. It may be your opinion, but it isn't true. And that is surely what we have a duty to try and do in this place. My Lords, process, procedure, governance. During our debates on the illegal migration bill and on the treaty, I complained that we had not been treated properly as a select committee in the way that you would expect select committees to be treated. Suella Braverman, the then Home Secretary, declined to appear before the Select Committee. We didn't see James Cleverly in the context of this bill. We did, however, see the Lord Chancellor, Alex Chalk, and I pay tribute to him and the way in which he delivered his evidence and took the questions that we put to him. But as the noble and learned Lord has just said to it, it is the duty of the Home Secretary of the day to explain what the intentions of their legislation is. And if there is anxiety about something like as important as compatibility statements, for them to explain why they feel unable to give it. My noble and learned friend, Lord Anderson of Ipswich, rightly said that we are ill-equipped to make these kinds of decisions in Parliament. I didn't serve as long as the noble Lord Howard, although we did have the distinction of contesting the same parliamentary seat in the heart of Liverpool on separate occasions, or indeed as long as the noble Lord Hailsham. But I rather agree with what the noble Lord Tugendhat said to the House a few moments ago about the way in which legislation was and has traditionally been dealt with both in another place and here. I cannot remember select committees being treated by secretaries of state in the way that I've just described, and thinking all the way back to the 1981 Nationality Bill, on which I spoke many times, there were opportunities to hear the arguments, to discuss the implications, and to make appropriate amendments. I have not felt that about this legislation or that which preceded it. I think it's been pushed through in a pell-mell way, bringing to mind the thought that if you enact legislation in a hurry, then you will end up repenting at some leisure. My Lords, let me take you for a moment, if I may, to page 15 of the report, because this comes right down to the role of the UNHCR and safety. As of January 2024, as recently, therefore, as last month, UNHCR had not observed changes in the practice of asylum adjudication that would overcome the concerns set out in its 2022 analysis and in the detailed evidence presented to the Supreme Court. The Supreme Court, not the House of Commons, not the House of Lords, relied on UNHCR when it came to a decision about questions of fact. Let me quote again from the report. UNHCR notes the detailed legally binding commitments now set out in the treaty, which, if enacted in law and fully implemented in practice, would address certain key deficiencies in the Rwandan asylum system identified by the Supreme Court that would, however, require sustained long-term efforts, the results of which may only be assessed over time. Well, clearly we haven't had the time to make those assessments, and again we are being urged to rush pell-mell. Two witnesses, and I won't detain the House much longer, Professor Tom Hickman, KC, said this to the committee. Parliament is effectively being asked to exercise a judicial function, to assess evidence, to look in detailed facts, and effectively to distinguish the Supreme Court's judgment, to say that things have moved on and it's not binding on Parliament. I don't mean in a non-legal way, in making its judgment. In my view, he said, that is an inappropriate exercise for Parliament to conduct. It is a judicial function. This was a view echoed by Professor Sarah Singer. I'll just read from paragraph 57, one sentence. To contradict the Supreme Court in this way is perhaps not showing the respect to the court that should be owed as a constitutional principle. And my Lords, in the summary on page 35, I will conclude with this. We've considered the government's evidence that Rwanda is now safe, but have also heard from witnesses and bodies, including the UNHCR, that Rwanda remains unsafe, or at least that there's not enough evidence available at this point to be sure of its safety. Overall, we cannot be clear that the position reached on Rwanda's safety by the country's most senior court is no longer correct. In any event, the courts remain the most appropriate branch of the state to resolve contested issues of fact, so the question of Rwanda's safety should best be determined, not by legislation, but allowing the courts to consider the new treaty and the latest developments on the ground. My Lords, for all those reasons, I believe Lady Chakrabarti has done the House a great favour in bringing these committee stage amendments to the House. She's already shown her willingness to think further about whether they might be applied in other ways. That's what committee stage is surely all about. And I think that the tone that's been struck in the course of this debate is one which behoves members of your Lordship's House to think very deeply, and I would commend this report to the House.
Lord, can I welcome the point made by Lord Alton about the tone of this debate, and particularly the speech of the Baroness Chakrabarti, which I thought I warmly welcomed her obvious desire to find some way forward in this difficult area, which we certainly need to do. But there is, I'm afraid to say, a rock in the way, or a difficulty in the way, which is of her amendment, which is this, that it makes a classic mistake, which is to take two separate organisations with different objectives and obligations and place one with a veto over the other. Here, the UNHCR has a veto in practice, it's my reading of the words here, a veto in practice over what the UK government can do. This is the difficulty. And therefore, she used the word stalemate. I think her proposals would also lead to a stalemate, while the UNHCR went on forever, we know not when, to say whether or not Rwanda was safe. and there would be probably debate and hostility and no eventual consensus as to whether it was safe. Surely a more sensible way forward would be to take the existing circumstances and existing practice, and for both sides to engage properly and responsibly with the other. We do have obligations to the UNHCR. We are obliged under the Refugee Convention to engage with the UNHCR, and so we should. We're obliged to take account of the social and humanitarian consequences for refugees, and so we should. But equally, the UNHCR should take into account the real responsibilities of governments to defend their borders in a sensible way in which their own democracies will expect. And if we can get those two working together, something sensible may emerge from it. And it already has done in Australia. I wish that we would always be quite so insular. For 10 years now, Australia has been operating an outsourcing policy of the kind to which the UK aspires. And it started off in precisely the same way, with precisely the advocates on each side, which we did. And in the end, the Australian government invited in the UNHCR at 3 different levels: at the Prime Ministerial level, at the Ministerial level, and at the ordinary regional level of civil servants and so forth, and they came to agreement of how it should work. And not only that, but there was the UNHCR, as a consequence of its willingness to get involved, had leverage, and it got out of the Australian government more legal routes for genuine asylum seekers. And the same should happen here. Our legal routes for asylum seekers are at present wholly unsatisfactory because they're confined to a small number of countries, and most countries in the world are excluded. My view of a proper immigration policy has always been that there should be a settled cap, which we put publicly to the people every year in Parliament. How many should we bring in? Within that cap, the priority should be to genuine asylum seekers, and only thereafter to economic migrants or people joining their families here. That is the right way to approach an immigration policy, a total immigration policy, of which this is only a small, numerically only a very small part. Therefore, I think that if we follow the Australian example, which has been now operating successfully and is supported by both parties, the current Labour Party in Australia has just reduced the cap on the number of immigrants allowed into the country because it's dissatisfied with the numbers going to Australia, which is a vast country after all. We have a similar problem, even more acute here. So if we follow that example of governments working within the existing acknowledged framework of our obligations to the international community, surely we can make some progress. If we hang on to that, too many bells and whistles of the kind which the House seems to want to, I'm afraid we will fail and not make the progress which is available to us here.
My Lords, this has been a very long debate, and I shall therefore be extremely brief. The Right Reverend Prelate, the Bishop of Southwark, spoke very powerfully, as indeed have many extremely well-qualified lawyers. So I'm not going to talk about the law. But what I would say is that I found myself very much in agreement with Lord Howard of Lympney. I thought he was putting very important points, and I hope that they will be reflected later in our debates. All I would say, I think, is that we also need to take account of what one might call the real world. And I'm glad to see that the front bench of the opposition are being very cautious at this point. Perhaps that's one of their reasons. The reality is that the government have lost control of our borders. And even the backlog of asylum seekers is enough to fill the largest stadium in the UK. And there's deep public anger, I regret to say, but there is. And we have to take that into account, and I'm sure the Commons will take it into account when we take this forward. It seems to me, therefore, that it's for the government to take action to bring all this under control, and for us to give some advice as to how that could best be done. But let's not lose sight of that. This is a very difficult, a very widely resented situation, and we need to be careful ourselves.
I wish to speak to this clause and these group of amendments, and in so doing I apologise to the House that I couldn't be here for second reading. Even though I was on the estate, I'd got a very bad chest infection and was coughing and spluttering, which I didn't think would add to the debate that was had. So I did listen to the debate in my office and have subsequently read the Hansard and also was here and very much so proud to support and vote for my noble friend Lord German's fatal amendment to the bill. I also draw the House to my interest in the register on this issue. I will try not to do a second reading, but keep my comments to this particular clause and the amendments. And I think these amendments are quite important based on what I would call this candy floss clause, because it is a bit like a candy floss. The government are trying to make it big, enticing and sweet, but the moment you touch it, it starts to disintegrate because you realise it is built on nothing. 1.3 says that the government of the Republic of Rwanda, as in accordance with the Rwanda Treaty, and these are the important comments, agreed to fulfil the following obligations. Agreed to fulfil. They haven't, my lords, yet done that, and they haven't given an indication of how they will do that. And therefore, I think it's very important before any person is sent to Rwanda that those obligations are fulfilled, and there needs to be some form of independent assessment of how that is done. Now, normally, in the normal course of the rule of law, that would be the courts of this land. So, what the noble lady Chakrabarti is trying to do is put at least some form of independent assessment. People may argue whether it is independent, that the UNHCR and its role in the legal understanding of refugees and safe countries, I think, is well understood. I do have a slight problem with the noble lady in the fact that it's just one set of evidence, and clearly courts would normally look at a wider range of evidence. But it is important, I think, that in Amendment 34 there is a rebuttable presumption, and that, I assume, would at some point give some leeway and doorway to the courts to be able to test that, and the legality of the decision made by the executive can be reviewed by the independent judiciary. It will be interesting to see if that is the aim of the noble lady's amendment. And I particularly would ask the Minister, the noble Lord the Minister, when responding to these amendments, to pick up what my noble friend Lady Hamway has said with regards to the incompatibility at times between Rwanda and the laws of this land and the obligations and treaties that have been signed, and particularly how refugees' claims would be assessed in Rwanda, and where there is incompatibility between the laws or obligations of Rwanda and the UK, exactly how those contradictions will be dealt with.
I think a majority of those who've spoken have apologised for not being here at second reading. I'm worried. I think I ought to apologise for having been here at second and having spoken then and having spoken a week earlier on the treaty. So I've done the apples and pears, and I've done the rule of law, and I've done the international reputation, and I don't want to bore the House anymore. So let me just say that I think the aim shared by the noble Lord Garnier and the noble Lord Anderson of making the bill, if pointless, harmless, or harmless though still pointless, clause 1, I think that's impossible. I think we're dealing with a bill which it is very hard to make acceptable. On the Baroness Chakrabarti's amendments, Of course, I understand what she is hoping to do, and I share that. I do think we need to take account of the fact that we have voted in this House on the report of the International Agreements Committee that Rwanda is not yet safe. And we've done that not in an off-the-cuff way. We've done that on the basis of a reasoned report which was written on the basis of a stack of evidence submitted to the International Agreements Committee, of which I'm a member. A House voted that it wasn't safe. Therefore, the noble Lord Hailsham is completely correct. How can we possibly now stand on our heads and say it is the judgment of Parliament that Rwanda is safe, as if we could do that anyway, as if we cannot legislate apples, pears, cats, dogs. I do think we need to have some sort of triggering, some sort of commencement mechanism, which means that the bill or the act rather, doesn't come into force until Rwanda can be seen to be safe. And the International Agreements Committee set out the 10 areas in which changes were required. I am uneasy about conferring the role on the UN High Commissioner for Refugees, although I think that the government have now accepted that his role, one of his roles, is supervising and monitoring the operation of the Refugee Convention. I'm not sure that it's right to ask UNHCR to undertake this task. We are only one of the signatories of the convention. So is Rwanda. And as he said in the memorandum that he submitted in relation to the treaty, UNHCR continues to engage bilaterally with the government of Rwanda on specific incidents of concern, and will continue to offer technical advice and support to the government of Rwanda to strengthen its asylum system and the protection of all refugees as part of its mandated responsibilities. Now, for us to ask it to act as advisors to us might, to UNHCR, I don't know, might seem to be difficult. I note that UNHCR did not want to give evidence to the International Agreements Committee. It seems to me that UNHCR may well feel this is something you have to sort out for yourselves. Don't drag me in. But we do need to have someone. In later groupings, we can consider the proposals for an independent reviewer, or the proposal in the name of noble Lord Hope for using the monitoring committee in the set up in the treaty, using it for that purpose. I'm not sure about that. I'm on the independent reviewer myself, but these are for later groupings. For now, I just want to utter a word of caution about whether this is really appropriate, and whether we wouldn't be talking about a forced marriage here. The government certainly don't want to involve UNHCR. I'm not 100% sure that UNHCR wants to get involved either. The important amendments in this group, for me, are 5 and 6, the ones that say that instead of having the bill say that Rwanda is safe, the bill would say that Rwanda will become safe when the conditions, for example, those listed by the International Agreements Committee for safety, they are met. So it would change the tense from is to will be, forward-looking. And that's where I feel most strongly about the amendments in this group.
My Lords, in speaking, can I first draw attention to my interests? I'm supported by the RAMP Group, RAMP project. We've strayed very widely, obviously, across the whole of Clause 1 in this debate. And, of course, what we are here to do is to discuss the specific amendments which are before us. But I think I should just start by the assertion, of course, that this Parliament finds Rwanda safe. I did look up the companion to see what the role is of resolutions of this House. And it is the resolution of this House which is the determination of this House. And the determination of this House at this moment, currently, is that Rwanda is not safe. So that is the view of which the government is trying to make us change our minds. So we need to bear that in mind first of all. The second broader aspiration and broader point that has been drawn out, and largely by Lord Horan, was of course the issue of offshoring versus offloading. We had this debate at second reading, and I think that what Lord Horan was talking about was offshoring, where you make the determination about whether people are right to come here, and then they come here. But this is not offshoring, this is offloading, where the government hands over the responsibility to another country in order to be able to accept them, and there is no way back. And it's a permanent situation.
I think he means outsourcing, and it is precisely what the Australians do.
Indeed. What the Australians did was that they checked whether people were ready to come to Australia.
Over to the government of Nauru over Solomon Islands.
Yes, they did not. I'm sorry. The facts are otherwise. But the essential thing is, the point is that they were doing this work, and whatever the noble lord thinks of the situation, it's not what I think, but we can check the facts. But they were doing it in order that people could be admitted to Australia. That was the point. It was doing it somewhere else in order that they could come to Australia. So trying to clear that knowledge and understanding, which we did do in second reading, on these amendments in particular, I think the first thing is that what we can say is that introducing scrutiny on the safety of Rwanda is a necessary and essential point, given the resolution and determination of this House. So if the government wants to proceed and get this House to change its mind, then what it has to do is to give us and find us, we have to find a route for ourselves which allows us to do so. It acknowledges that we don't have here in this House credible evidence in order to make a finding of safety, and whether or not we should do so is another matter, which we will examine in Group 2 to follow. But it's right that evidence should be broadly based, that whoever makes that decision, that we should not be just looking in one corner for evidence, but we should be looking at the evidence of NGOs, the civil society, working groups who were on the ground in Rwanda, in order to find out exactly whether the decision is the correct one. And so for us, I don't think we would limit the advice to the advice of that of the United Nations, HCR, even if they were prepared to do so, but we do take advice that they do give us. I just want to mention the issue which Noble Lord Howard said at the outset. He said that outsourcing a positive recommendation on an asylum case to the UNHCR would be unacceptable, that we don't actually give this decision to another body. Yet at the same time, right now, as we speak, the Home Office and its report of January the 12th showed this quite clearly, that the only remaining global resettlement scheme is the UK resettlement scheme, and that relies exclusively on a positive reference from the UNHCR. So the UK does not seek to influence the cases that the UNHCR refer. The fact is that they have actually passed that responsibility to the UNHCR already to do so. So it is clear that we need a much broader, I think, understanding of what is the information and advice that we need. The Amendment 34 before us, of course, does create a rebuttable presumption, and I think that is absolutely essential, that this is not going to be seen as a rock which can never be moved if the situation were to change one way or the other, from safe to unsafe in the future. And it is right, of course, that court jurisdiction is restored, recognising the rule of law and the separation of powers. More of that to come. On our amendments 11 and 12, in my name and that of Baroness Hamway, it is right that I think that the decisions that are taken on refugees who have applied or who are seeking asylum with us, who are being sent to Rwanda for having their cases heard, should be subject to the rules which we would impose and we impose ourselves, the laws and rules that we have in front of us. So what Amendments 11 and 12 do say is we recognise the UK's laws and responsibilities in this matter, and we want Rwanda to utilise those, because of the standards which we accept, we want to see those standards being accepted in Rwanda. So, in conclusion, I think there are these amendments give us some basis for thought. I think they give us some basis for some major proposals in the future. But at the present moment, I think that they are signposts rather than a milestone.
My Lord, it's a great privilege to wind up this group of amendments for His Majesty's opposition, and the quality of the contributions has been truly outstanding. Can I start by saying to Lord Green and Lord Howard, whatever our view on the various amendments, including within this group and the other groups, we are fundamentally and totally opposed to the whole bill and have voted against it at all stages. So I think that lays out our position fairly clearly with respect to what we think about the bill. And can I just say to Viscount Helsham, I thought it was helpful for him to lay out again as we start this debate in committee to say that the debate is not about stopping illegal migration or indeed reducing immigration, but how we do it, and the bill is not the way to do it with respect to that. And that's the whole point. I think Viscount Helsham was right to remind us of that. Can I also say that we support the thrust of the amendments 3 and 7 and various Lords, Lord Anderson Garnet, the Bishop of Southwark, Baroness Chakrabarti herself, I come back to her lead amendment in a moment, Lord Hannay, Lord Kerr, and many others, which goes to the heart of the bill, and however the various amendments have tried to do it. But 1.2b, which replaces a judicial finding of fact with Parliament simply declaring that Rwanda is safe, irrespective of the judgment of the Supreme Court, without going into the legal niceties that we've heard. It does seem pretty remarkable to me that a Parliament makes a judgment, the court has got it wrong, and we're actually just going to change that without reference to that court itself. Of course, the one word missing, which gives great credibility to many of the contributions made in your Lordship's House this afternoon from 1.2b, is that this Act gives effect to the judgment of Parliament that the Republic of Rwanda is a safe country. Of course, what many of your Lordships have said, what the various committees that have reported on this bill have said, is that what the question is, that this part of the bill is saying that Rwanda is safe now. It's not saying that it will be safe, will become safe. It's saying that it's safe now. And the Supreme Court is saying that is the point of conflict, of difference between us. We haven't actually said the government can't act in this way. I would have thought the government would have been pleased about that and saying, look, the Supreme Court have said what we're doing is actually conforms to international law, but what you aren't doing is to actually say, what you can't say is that Rwanda is safe now. And the government is saying, well, don't worry about that, we'll just pass the law saying it is, which is what the point of conflict about it. And that flies in the face there of the Supreme Court, of the International Arrangements Committee, and many others. Can I also say that I thought Lord Tugendhat's contribution was remarkable in its honesty and openness, and about him saying, as a member of the Conservative Party for decades, he was, and I apologise if I get his words wrong, but disappointed perhaps in the government coming forward with legislation such as this, which he felt flew in the traditions of the Conservative Party and was actually legislation that Margaret Thatcher herself would have refused because it flew in the face of her belief that governments had to act in accordance with the law, and that it was the Constitution that was at stake if you did not do that. And that's what many of the amendments before us in this particular group seek to reassert the principle that this country has always operated on, that this Parliament operates according to the law. Of course, parliamentary sovereignty is paramount. Of course, Parliament can pass what it wants, but the unwritten Constitution says the part of that is important that goes along with that is the belief that Parliament will always operate according to the law, even whilst recognising the sovereign power that it has. Turning to Baroness Chakrabarty's amendments, or the lead member that she is for those, to say that we broadly support much of that. And I think in answer to Lord Howard's contribution, I thought Baroness Chakrabarty, in the spirit of committee, actually said if that isn't right, if she hasn't got it completely right, then perhaps that amendment will need to be changed. And that's what the whole point of committee is. And accepting that Lord Howard may actually have a point about that, I thought Baroness Chakrabarty turning around and saying that maybe the UNHCR being the sole person that advises or prevents the government from acting might not be the best way forward. But I tell you what I do think, and I wanted to draw particular attention to, and I think many of your lordships, particularly Baroness Hennig and my noble friend Lord Faulkner mentioned, and indeed Baroness Chakrabarty did in her own remarks, in the amendments 1 and 2, and it may be flowery language that governments now put in the front of the bill. I'm sure we did it when we were in government, and hopefully when we're in government in the future, we may well do it again. But the serious point in 1 and 2 is that the amendment adds in Amendment 1 adds the purpose of compliance with the rule of law to that of deterrence. And in Amendment 2, the second purpose is to ensure compliance with the domestic. And your lordships, I would want to highlight in the contribution, the couple of minutes that I'll speak for, compliance with the domestic and international rule of law. And I think that is really the fundamental point before us. Any bill, any law that we pass, of course, should be compliant with international law. That's why our country has that standing across the world. What on earth are we doing? Why Amendment 1 and 2, that part of it, is so important? Do we not care that the UNHCR has said what we're passing is not compliant with the Refugee Convention, is not compliant with international law? Is it of no consequence to us that the UNHCR is saying that? Have we gone beyond caring? Are we not bothered? Are we simply saying it's an irrelevance? If that's so, I honestly cannot believe that is where we want our country to go. What are we doing? Ministers from that dispatch box have got up with respect to Putin and the Ukraine and said we are not going to stand for somebody who drives a coach and horses through the international rules-based order. That is what this country has always stood for. That is what we are proud of. And therefore we are going to continue that tradition. And we are right to do so. Why are we taking action against the Houthis in the Red Sea? I heard Earl Minto last week say it was because we are not going to have a group of terrorists actually holding the world's trading system to ransom and breaking every single rule of the international rules-based order. Rules that we adhere to, conventions that we've signed. We've done that by being a sovereign parliament that's taken the decision that in certain areas of international life, it is better to pool sovereignty, to stand together, because if you do that, that's the way to overcome common problems. Not to retreat back into your own country, but to work together to overcome that. And that's why the compliance with international law is important. And within the context of this bill, what Baroness Chakrabarty's amendment with the Archbishop and I think it was Viscount Helsham, but anyway, the others that signed those amendments were seeking to do was to say, as a point of principle, a bill dealing with migration, refugees, asylum, whatever, should comply with international law. I am astonished astounded. I find it unbelievable that His Majesty's government has to be reminded of the fact that we want our government to comply with international law. I would have thought that would have been a statement of the obvious. I would have thought that would have been something around which all of us could have united. Whatever party we are, whatever faith we are, we could have been stood together and said, that is why we are proud of our country. What are we going to say? And I'll finish with this. When we go to the United Nations, when we go to the Council of Europe, when we go to the Commonwealth, when we go, even if we still have talks with the EU, when we go to NATO, when we go to any other part of the world where there's an international organisation, how on earth can we lecture those people about conforming to the international rules-based order when we ourselves are prepared to drive a coach and horses through it with respect to this amendment that is before us here? And that's why much of what Baroness Chakrabarti and many others have said in their various amendments before us are so important. And the government may dismiss it, but they'll not win the argument on this one.
My Lords, I'd like to thank all noble lords who've spoken in this debate. And my Lords, the overriding purpose of this bill is to ensure that Parliament's sovereign view that Rwanda is a safe country is accepted and interpreted by the courts to prevent legal challenge which seek to delay removals and prevent us from taking control of our borders. My noble friend Viscount Helsham's Amendments 3 and 7 suggest that this legislation is replacing a judicial finding of fact. My Lords, the government respects the decision of the Supreme Court in its judgment. However, the judgment was based on information provided to the court on Rwanda up until the summer of 2022, and their lordships recognised, explicitly and in terms, that those deficiencies could be addressed in the future. In response, the Home Secretary signed a new internationally binding treaty between the United Kingdom and the government of Rwanda, which responds to and resolves the concerns raised by the court. Alongside this treaty, the government have also introduced this bill, the Safety of Rwanda Asylum and Immigration Bill, which buttresses the treaty and supports the relocation of a person to Rwanda under the Immigration Acts. My Lords, it's our view that Parliament and the government are appropriately equipped to address the sensitive policy issues involved in this legislation and ultimately tackling the major global challenge of illegal migration. Amendments 1, 2, 5 and 34, tabled by the noble lady Baroness Chakrabarti, seek to include a second purpose to this bill, which is to ensure compliance with the rule of law by requiring positive UNHCR advice on the safety of Rwanda to be laid before Parliament before individuals can be removed to Rwanda. It also requires the UNHCR to consult with international experts before providing the advice to the Government and Secretary of State. We consider that the terms of the treaty, which have been carefully agreed with the Government of Rwanda and will be binding in international law, to be sufficient to ensure that those relocated under the partnership will be offered safety and protection with no risk of refoulement. The Government has conducted its own assessment as to the safety of Rwanda, reflected in the published policy statement and the comprehensive supporting evidence, including 2 detailed country information notes and accompanying annexes, which have been published online. This evidence draws on a wide range of sources in addition to the institutional expertise of the Home Office, the Foreign, Commonwealth and Development Office as experts on the bilateral relationship between the UK and Rwanda. Indeed, Annex 2 to the Country Information Notes is comprised entirely of UNHCR evidence, which has already been factored into the government's assessment. It is also the government's understanding that the UNHCR has not been consulted or worked with peers on this or these amendments, and it's unclear what is meant by international experts or who bears the cost of such consultation. The provisions in the bill that prevent challenge on the grounds that Rwanda is not a safe country generally reflect the government's confidence in the assurances of the treaty and in Rwanda's commitment and capability to deliver against these obligations. As I've set out, the Home Office has reviewed a wide range of sources, including evidence from the UNHCR, via an established process for assessing country safety. This is therefore the most appropriate assessment on which to rely. It would not be right for our ability to deliver this policy, which is key to our commitment to stop the boats, to be left solely dependent on a further independent assessment by an external body like UNHCR, who, we further note, has not been consulted or worked with peers on these amendments.
My noble friend, on that point, would he consider a domestic assessor, like, for example, the Joint Committee of Human Rights, if they were to advise? Would he accept that?
My Lord, Lords, one of the groups that we're coming on to looks at the organisations and committees that are set up under the treaty. So I think we will return to that discussion as to the provisions of the treaty in respect to what my noble friend has just asked. It would not be right, as I say, to deliver our policy, which is key to our commitment to stop the boats, to be left solely dependent on this. But, my Lords, I'll turn now to Amendments 11 and 12, which were tabled by the noble Lord German, which seeks to ensure that individuals who are relocated to Rwanda must have any asylum claim determined and be treated in accordance with the UK's international obligations. My Lords, this is unnecessary in view of the comprehensive arrangements that we have in place with the government of Rwanda. It's deeply about supporting refugees. It works already with the UNHCR and hosts more than 135,000 refugees and asylum seekers, and it stands ready to relocate people and help them rebuild their lives. We will get again on to this in a later group, but perhaps, my Lords, I should just remind the House that the UNHCR has signed an agreement with the government of Rwanda and the African Union to continue the operations of the Emergency Transit Mechanism Centre in Rwanda, which the EU financially supports, having recently announced a further 22 million euros in support package for it. And indeed, as recently as late December, the UNHCR evacuated 153 asylum seekers from Libya to Rwanda. Now, the noble lady Baroness Hamwe asked about the international agreements that Rwanda has signed, and that is dealt with at paragraph 25 of the policy statement. And I'll read it for convenience. Rwanda is a signatory to key international agreements protecting the rights of refugees and those in need of international protection. It acceded to the Refugee Convention, as well as the 1967 Protocol in 1980. In 2006, it acceded to the 1954 Convention relating to the status of stateless persons and the 1961 Conventions on the reduction of statelessness. Regionally, it is a signatory of the Organisation of African Unity Convention on Refugees in Africa and the 2012 Kampala Convention. Paragraph 26 goes on to say Rwanda's obligations under these international agreements are embedded in its domestic legal provisions. The Rwandan constitution ensures international agreements Rwanda has ratified become domestic law in Rwanda. Article 28 of the constitution recognises the right of the refugees to seek asylum in Rwanda. So, my Lords, the presumption which appears to underpin this amendment is that Rwanda isn't capable of making good decisions and is somehow not committed to this partnership. My Lords, I disagree with that. Rwandans, perhaps more than most countries, understand the importance of providing protection to those who are needing it. And, my Lords, I think I would remind the House that my noble friend Baroness Verma spoke very powerfully on this particular subject during the second reading. My Lords, the core of this bill and the government's priority is to break the business model of the people smugglers. That will not happen if we undermine the central tenet of the bill, which is the effect of these amendments. And a point that was well addressed by my noble friend Lord Howard. We are a parliamentary democracy, and that means that Parliament is sovereign. Parliament itself is truly accountable, and I would therefore invite the noble lady Baroness Chakrabarti to withdraw her amendment.
Before the noble Lord sits down, could I ask him one question? If one looks at the bill and you have clause 1(2)(b), which says that Rwanda is a safe country, why is clause 1(3) necessary?
My Lords, I'm sorry, I had to just confirm that paragraph 1(3) is just a simple restatement of the various facts of the bill.
Before the noble Lord sits down, he's rather disappointed me because he declined totally to address any of the points that your Lordship's House voted for some nearly 2 weeks ago, and in particular the 10 criteria by which it would be possible to judge whether the government's statement that Rwanda was a safe place was actually true or not. Could he perhaps now stand up and deal with those 10 criteria? Because it would be quite interesting for the House to have his account of the government's view of those criteria and whether they have been met, and if they haven't been met, when they will be met, and what tests they will put them to.
Superb.
Well, my lords, this is committee, and I'm answering, or I'm speaking to the various amendments in this particular group. We get to another group which debates, as I've just reminded my noble friend Viscount Helsham, which debates the clauses in the treaty as regards the various committees and so on that are in place later in the day.
No, it's very boring, but could I ask the Minister if he can respond to my question about the legal status, the effect of Clause 1? I'm still not clear what attention we should pay to it were we to be in very formal proceedings rather than debating the situation broadly. In other words, if there is a breach of I don't know whether it can be called a breach of Clause 1, but if there is no compliance with Clause 1, then what informal legal terms?
It's simply the introduction to the bill, so I'm not entirely sure I get the drift of the noble lady's question.
Can he say whether he will formally be responding to the Joint Committee on Human Rights, especially before we reach report stage?
I would say to the noble lord, I haven't yet had a chance to read the report, which I believe was only published today, but I will, of course, be reading it in due course and responding accordingly.
The Minister seems to rely on the emergency transit mechanism that Rwanda works with the UNHCR on. Can he confirm that that mechanism has a maximum capacity of 700, is a temporary processing point for asylum seekers from Libya, and that none of the 1,453 evacuated to Rwanda have actually opted to stay in the country?
My lords, I don't rely on that at all. As I tried to explain during the course of my speech, there are a variety of aspects of the UNHCR's work which are included into our safety assessment. That is just one of them.
My lord, I apologise for interrupting, because I know my noble friend wants to sit down and sit down for good. But when he was speaking to Clause 1, 2, little b, was he speaking for Parliament or for the government?
As my noble friend is aware, I speak for the government.
Could the noble lord give an indication as to when the government will respond to the Constitution Committee of this House's report on the bill?
I'm afraid I don't know. I will find out.
Write to me with the answer. Thank you.
Any more? No. I am so grateful to all members of the committee from around the House for the constructive manner and tone with which these proceedings have been conducted over the first group. Noble Lords will forgive me if I don't mention every excellent contribution. They'll understand that's not a discourtesy to members of the committee, but hopefully a bit of kindness to those who have amendments to follow this evening. I'm particularly grateful actually to the noble Lord Howard of Limp for following immediately, because he was able to crystallise some key issues between us in relation to my suite of amendments in particular, but all the amendments in the first group. And I think he essentially had 2 points. One which I can embrace to some extent, and the other I can't. And I think he was the first to point out that in the way that I formulated my suite of amendments, I've given perhaps too determinative a role for the UNHCR. I explained the reason for that by way of a probe. It was because the Prime Minister said he was going to assuage the concerns of the Supreme Court. But nonetheless, I take the noble Lord's point, which was echoed by subsequent speeches, if less robustly. And so I would not, at the next stage in proceedings, hope to create a determinative role for the UNHCR, though I also note that many members of the committee, including the noble Lord the Minister himself, did refer to the important part that the UNHCR plays in the world in regard to refugees and the Convention. However, the second crucial point...
the point where she disagrees with me, may I thank her for her response to the first point which I made. Of course, I don't speak for the government, but no doubt we will consider the matter further when we get to the report.
Once more grateful to the noble lord. However, his second central point was really the big constitutional one, which is that Parliament is sovereign, and that's pretty much it, and that the Supreme Court's decision of the 15th of November was mere opinion rather than a determinative finding of fact in our system. I have to disagree with him, I'm afraid, about that, because essentially for the reasons outlined later in the debate by my noble and learned friend, Lord Falconer, and he in turn actually echoed some of the points made by the noble Lord Clerk of Nottingham at second reading about the dangers that lie if it is going to be possible in the future in our country for governments with large majorities, say, of whatever stripe, to use legislation to change, not just change any old finding of fact, but to change a finding of fact that was made recently by our highest court. That is not just silly to echo, it is silly to echo the noble and learned Lord Garnier, but it's very dangerous as well in a democracy that is built fundamentally and first upon the rule of law. Parliamentary sovereignty follows, but Parliament and the executive in particular has to have a little bit of respect for the independent referees of our democratic system. I was so grateful to the noble Lady Hellich for making the international point that follows from that, which is that the domestic rule of law is a bedrock of our system, but so a quarter of the way into the 21st century is the international rule of law, and all sorts of terrible consequences come when we don't respect that. And she cited wars of aggression, war crimes that in turn drive the displacement of people that is leading to the refugee crisis that governments around the world are trying to respond to. And therefore she's a great proponent, and we know this from her other work, a great proponent of the international rules-based order. I was also very grateful to the Right Reverend Prelate for speaking on behalf of his benches, the Bishop of Southwark, who reminded us of our duty of care to refugees. Like me, he's uncomfortable, the Church is very uncomfortable with offshoring at all, but nonetheless is engaging with this process, not a wrecking process, but a constitutional compromise, in the spirit with which I've been trying to address the noble Lord Howard's objections. And I was therefore also grateful to the noble Lord Hannay for saying what ultimately is the government's problem. Well, what we're really trying to do is to make sure there will be further factual assessments to meet, for example, the tests of your Lordship's International Agreements Committee, to make sure that Rwanda has become safe per the terms of the treaty before we deem it so. Not wrecking amendments, but an attempt to do our duty. I have to say, of the noble Viscount Hailsham's contribution, I hope he won't be cross with me for suggesting that he has really done his father proud today. Because that famous speech that so many of us read as students about the elective dictatorship was really in itself an answer to his noble friend Lord Howard, though that was in the 1970s, I think 1976, because Parliament is not just the House of Commons, whether we like it or not, whether we would all vote ourselves out of business. Parliament is both houses in the current system. And Parliament is not interchangeable with the government of the day, however large its majority. We do have to have checks and balances, and at the moment in our system, for all our defects in your Lordship's House, we are one House of Parliament, and Parliament is not interchangeable with government. And and facts, he went on to talk about how facts must be examined by due process of law, and he rightly, I think, flagged future, I know this might irritate the noble Lord the Minister, but he was right to flag future groups of amendments because they're all so interchangeable in the scheme of what is a very short bill, but a hugely controversial one. And so if it isn't to be the UNHCR, there has to be some other process of examining the facts on the ground before Parliament just signs up with the government of the day and says dogs are cats. And I think that's what I say to the noble Lord Garnier as well. I think most members of the committee would, if not all, would agree that the noble Lord Tugendhat's contribution was an incredibly powerful and, if I may say, poignant one. And I repeat points at second reading, this is a very unconservative bill. Whatever one thought of the late Lady Thatcher, she was on her own case committed to the domestic and international rule of law. Despite controversial politics that we would find controversial on our benches, she was committed to the rule of law. And those who served her as Attorneys General said that that was their experience too. I think that my noble friend, Lord Falconer of Thoroton, represented the Constitution Committee with great precision and not a bit of passion as well. He spoke of the 70-year commitment that this country has had to non-refoulement, which I think many of us now believe is part of customary international law rather than just one treaty or another. He echoed Your Lordship's International Agreements Committee that there is a lot more that needs to be done before the Rwanda Treaty can be the safeguard that the government relies on. And that is a lot of change, a lot of administrative and cultural change on the ground that doesn't happen overnight. It doesn't happen overnight in our own Home Office, let alone in the Republic of Rwanda. I was grateful also to the noble Lord Alton for representing the Joint Committee on Human Rights with its own similar and further criticisms of the bill in its current form, and his response to my noble friend Lady Rishi of Downpatrick was important in acknowledging the violence that we may be doing to that precious settlement in Northern Ireland every time we violate international law, the ECHR in particular. I was particularly grateful to the noble Lord Horam for the way in which he engaged, similarly to the manner that Lord Howard engaged, and also with his rather honest reflection that we have unsatisfactory safe legal routes to this country at the moment, and this bill doesn't address any of that. And he said he would like to prioritise refugees over economic migrants, and I listened to his comments carefully. I think I may have dealt with the concerns of Lord Kerr of Kinlochard in what I say about the ECHR. To my noble friend Lord Coker, I am so grateful for his support for the broad thrust of this suite of amendments, and in particular it is so comforting to know that any incumbent Labour government will be committed to the international and domestic rule of law. And so I finally say to the Minister, if the Rwanda Treaty is, as he said, binding and sufficient, wasn't the Refugee Convention of 1951 binding and sufficient as well? It's a slightly circular argument to rely on one and not so much on the other. We are not traducing Rwanda, my lords. We are just honouring the recommendations of committees of this House and of our Supreme Court, which is why we must have on the face of the bill a commitment to compliance with the law. We must substitute is with may become safe, because that is the truth. We must have some kind of independent fact-finding assessment before we say that Rwanda is safe. Safety must only be a rebuttable presumption, as in keeping with prior statutes, including conservative asylum statutes, and the courts must not be ousted from their proper role that is fact-finding and rights-protecting in our Constitution. But for the moment, my lords, I beg to withdraw my amendments.
Is it your Lordship's pleasure the amendment be withdrawn? The amendment is by leave withdrawn. Amendments 2 and 3, Baroness Chakrabarty, not moved? Not moved? Amendment 4, the Lord German. Not moved. Amendment 5, Baroness Chakrabarty. Not moved. Amendment 6, the Lord Hope of Craighead.
Sorry,
Do you wish to speak to Amendment 4, Lord German? Yes.
Yes. I thought my apologies to my lords. I thought I was referring to the amendments in the first group. I am now speaking to Amendment 4 and also to a suite of amendments which go right throughout this bill, and perhaps it indicates the nature of the way in which all these things are interconnected, because these suite of amendments will deal with a lot of the concerns which have been raised in this House in the course of Group 1 and will be relevant to any changes that we might pursue in report stage. First of all, the suite of amendments, in summary, remove the absolute nature of the declaration that Rwanda is safe. They enable the courts to consider the safety issue. They require the Secretary of State and not Parliament to judge when Rwanda is safe, and ensures that all the measures this House has considered in its resolution of the treaty to be operational and functioning according to our international obligations before the Secretary of State can lay a commencement order before Parliament. My Lords, this bill, as we've heard, deems Rwanda to be safe, regardless of whether it is in fact safe, and this House has already determined that it's not yet safe. Unlike the use of deeming clauses in domestic legislation, this deeming subclause is being used alongside an international obligation, which, as the Bar Council and as evidence to the JCHR, among others, points out, deeming Rwanda to be safe in order to meet the UK's international obligations under the ECHR and the Refugee Convention steps outside the domestic use of deeming clauses. And this is particularly so when you take into account the conclusions reached by the UNHCR that this bill and the treaty, and I quote, does not meet the required standards relating to the legality and appropriateness of the transfer of asylum seekers and is not compatible with international refugee law. And if the arguments which the government puts forward about it being in context of the international laws, then why don't they let the courts have their say finally about this matter? Now, there are some on the government side who are comfortable about overriding our international obligations, maintaining that it is perfectly acceptable to be incompatible with international rules, laws, commitments and obligations of which we are part. But, my Lords, I'm not a lawyer, but having read all the evidence to committees of this House, of the other House, and of all the people who have put evidence before us, they are a minority, it seems, of legal opinion. And we have witnessed incredible displays of legal acrobatics, most of it on the head of a pin. But fundamentally, my Lords, based on Article 27 of the Vienna Convention on the Law of Treaties, no rule of a state's internal law can be used to justify a breach of an international obligation. And further, as our own Constitution Committee states, to legislate in this way could undermine our constitutional principle of the rule of law. And separately, back in 2020 and again recently, said respect for the rule of law requires respect for international law. And today we have that view expressed by the report of the JCHR. We will hear much more on the rule of law and the words of Dicey, but this suite of amendments, taken as a whole, will ensure adherence to the rule of law, reinstate the role of the courts, protect human rights and meet our international obligations. Fundamentally, these amendments seek to safeguard and uphold the UK's constitution and the rule of law. It's deeply problematic that the terms of the UK-Rwanda agreement have not yet been met, especially as the government has deemed it as the basis for the declaration in this bill that Rwanda is in fact safe. And in fact, in their own policy statement, they're called, and the government says they're assurances and commitments. Assurances and commitments, my lords, are not things which are happening at this moment. So through these amendments, we are seeking to ensure that the final arbiter on the safety of Rwanda ultimately lies with the judiciary and not with Parliament. The Secretary of State would come to a decision on the safety of Rwanda, but the legality of this decision can, however, be reviewed by the judiciary. This enables the proper role of the independent judiciary, of our domestic courts and tribunals, to review the legality of the Secretary of State's actions and decisions. The amendments in this week would mean that the Secretary of State should only deem Rwanda safe if it is safe for every person of every description: women, ethnic minorities, religion, LGBTQI+, those in power, those whose political opinion differs from those in power, every nationality. In coming to their conclusion, the laws of Rwanda and how they are applied should be scrutinised together with evidence from international bodies and civil society organisations. Only when the steps set out in Amendment 84, of which the Noble Lord the Minister spoke earlier, and that we've reached them already, Amendment 84 have been met, could the Act come into force. So in replying, can the Noble the Minister tell the House, I think it was Lord Hannay's question as well, which of the matters listed in Amendment 84 1C are currently in place, which are the ones which will be in place soon, and which ones of them will be operational on the date they think this bill will be enacted. And for those who've got the 84 1C in front of you, it is the 10 issues raised by the committee which reported to this House on the treaty. And as this House has determined in its resolution on the treaty, it's critically important for the safety of those concerned that any assessment of safety is completed before this Act comes into force. The judgment about whether Rwanda is safe could be one of life and death. The Supreme Court has already made a factual assessment. Parliament should not be legislating to reverse the Supreme Court's factual assessment, and at the same time tying the hands of the judiciary and one moment, I'll finish the sentence, if I may, and requiring them to ignore facts placed before them. I did say... No.
He should have sat down. Thank you. I thank the Noble Lord for giving way. He has said repeatedly that the Supreme Court has held as a fact that Rwanda is an unsafe country. If one looks at the judgment of the Supreme Court in paragraph 105, the Noble Lord will see that Lord Reid, the President of the Supreme Court, said that Rwanda was unsafe at the time that the Divisional Court was considering the evidence. And as my noble friend the Minister said in the last group, the short point is this: the question that this Parliament is determining as to the safety of Rwanda is in the light of the current new arrangements.
The other clause that the Noble Lord did not refer to in the Supreme Court judgment, of course, is that it will take a considerable time for those matters to take place. And that is why I have asked the Minister right then in this chamber, and having heard the views of the Treaties Committee of this House, and having heard the matters which they raised, having taken evidence just in this last month, whether or not the items in Amendment 84 1C are in place now. Are they operational? Which ones will be in place and by when? Because that is the judgment, if we follow the Noble Lord's remarks, that is the judgment we are trying to make now. Certainly.
It's not only a question of whether they're in place, but whether Rwanda is compliant and remains compliant, and whether there are any other reasons to doubt the safety of Rwanda.
Indeed, and that is why in the suite of amendments, the Secretary of State has to take the advice of a number of organisations, not one in particular, but a number of organisations. It has to produce the evidence to show that it is in place, it is operational, and it is working according to the decisions that were originally in place as wanting to see this thing through. Yeah, sure.
Is it right that what perhaps the Noble Lord had in mind when referring to the Supreme Court judgment was its words that it thought that the problems in Rwanda were not a lack of good faith on the part of Rwanda, but, quote, its practical ability to fulfil its assurances, at least in the short term, in the light of the present deficiencies of the Rwandan asylum system, the past and continuing practices of refoulement, and the scale of the changes in procedure, understanding and culture which are required. And the Noble Lord, Lord Jermyn, might also have had in mind that it, the Supreme Court that is, identified a culture within Rwanda of, at best, inadequate understanding of Rwanda's obligations under the Refugee Convention. And would it be the case that Lord Jermyn might have been also rather worried that simply entering into an agreement saying we won't refoul from a date which I assume would be about a month or two from today, it sits rather unkindly against that assessment by the Supreme Court? But am I right in also saying that Lord Jermyn would have been very heartened by Lord Sharp, who said he accepted all that the Supreme Court had said?
I'd love to say yes to a leading question from a leading lawyer. However, he's absolutely right, of course. And for those words added to what I earlier said, and also paragraph 104 of which we've already had referred to, the necessary changes may not be straightforward, as they require an appreciation that the current approach is inadequate, a change of attitudes and effective training and monitoring. There are, if you read the Supreme Court judgment, you'll know what we have to test in order to be able to prove its safety. And that is what the committees of this House have been trying to do. So what this suite of amendments does, of course, is it turns it all around. It says it is the judgment of the government which they would have to bring forward an order for the House to accept, but before they do so, they'd have to address all the issues which are in Amendment 84(1)(c). They would also have to consult with and have to be certain that they have reached the case. And if, at the end, Parliament so approved what the government's order that he put before it, then the courts could intervene and test it on the basis of fact. That seems to me to be what our current procedure is for dealing with issues of this sort. So it's what, I'm loath to say this is back to the future, but what this is keeping in track where we stand as a Parliament, how we make decisions, and where those decisions are tested and where they can be tested in the courts. My Lords, we need to stand, we can't allow a dangerous precedent to be set with this overreach of Parliament's role. The courts need to remain in check, the check and the balance on the exercise of the Secretary of State's power. And Parliament cannot be allowed to overturn the evidence-based findings of fact made by the highest court in the UK, given that at the present moment this bill it is there forever. It is not a bill which looks what happens in the future. So we need to stand firm against the government's attempt to subvert the separation of powers in this country. Today, this is about asylum seekers. Tomorrow, this precedent will be applied to the next group who find themselves as the latest government scapegoat. I want to end with the words of the late Noble Lord Judge in this chamber, and I was sitting here and listening to him, and I can remember them, and I hear them echoing in my head now. He said, "The rule of law is a bulwark against authoritarian incursion, and even the smallest incursion threatens it." My Lords, those are wise words, and this suite of amendments seeks to uphold the principle he espoused so powerfully. I beg to move.
Amendment proposed. Clause 1, page 1, line 11. Leave out Parliament and insert the Secretary of State.
I regretted I didn't able to take part in the previous discussion in the committee because I was on the train and it began. But, my Lords, I think the point that's been made here is an important one, and it wasn't one that I heard elaborated on during the debate on the first grouping of the amendments, because without wishing in any way to disparage Rwanda, countries in that part of the world do have a habit from time to time of changing their regimes, and those regimes often have very different characteristics. And if you are approaching this problem, which it seems to be entirely reasonable in all the circumstances, that the country where the asylum seekers may end up is one that should be safe, it doesn't follow that once it's been ruled to be safe, it then continues to be safe. And it seems to me that the problem with clause 1(2)(b) is that if the wording like that remains as it is now, even if you go through the procedures the noble Lord German is discussing, once there's been a ruling that the country is safe, there is no means to return to the question if circumstances fundamentally and damagingly change.
Before my noble friend sits down, perhaps I might commend to him the concept of the rolling sunset, therefore, which you will find in Amendments 81 and 82 to this bill. To this bill.
Very interested in the noble Lord German's amendment. On one view, what the amendment is saying is there can be appropriate review of that by the courts, and I assume that the noble Lord German has in mind judicial review in relation to it. So it would be the decision of the Secretary of State that was judicially reviewable. I wonder if what's then envisaged by the noble Lord German, whether it is or whether it isn't, it might be worth thinking about, that once that decision is made, and if it were upheld by the courts on the basis that there was a proper basis that a Secretary of State could reach that decision, then in general terms, the question of whether or not the country was safe would not thereafter be open to be considered by the Immigration Office. I wouldn't be in favour of that as a matter of principle, but if one's looking for a compromise, and it was something that the noble Lord Anderson of Ipswich touched upon, and it may be dealt with in later amendments, I would be very interested to hear what the view of the government was in relation to a situation where, in effect, the Secretary of State had to make a proper decision addressing the proper considerations, and that decision was then open to judicial review. Could that be a compromise?
Lord, I hadn't intended to intervene in this debate, but the noble Lord Faulkner has just raised an extremely interesting point, because what he has suggested is that a decision of the Secretary of State, in the light of the consideration of the factors to which the noble Lord German has referred, should be subject to judicial review. Now, the principles of judicial review are clear. On judicial review, the court does not substitute its own view of matters. It assesses whether the Secretary of State came to a reasonable decision which he could have come to. One of the problems, and I'm straying and departing somewhat from the view of the government, one of the problems which I have with the decision of the Supreme Court is that the decision of the Supreme Court was not based on the principles of judicial review. The Divisional Court did approach it on that basis, and the Supreme Court said that was wrong. And the Supreme Court, relying on precedents which have never received the authority of Parliament or statute, decided that it shouldn't apply the principles of judicial review, but it should decide these matters for itself. That's a very important distinction between what happened in this case, in the case which gave rise to this legislation, and the procedure which is now being proposed by the noble Lord Faulkner.
My Lords, I rise with some hesitancy in the middle of a rather technical debate, but I do have a couple of points on this particular group that I'd like to make. And this committee has already heard from my noble friend Baroness Jones of Moulscombe, who in her inimitable way made it very clear that the Green Party remains utterly opposed to this entire bill, and we greatly regret that we did indeed give it a second reading. But given we are where we are, listening to the first group of debates, a word that kept coming up again and again, and I think might be surprising to people listening outside this committee, was the word silly. And of course, what we're talking about is absolutely deadly serious. But I think it's interesting if you look up the definitions of silly, as I did, one of which is showing a lack of common sense or judgment. And I think those two, common sense and judgment, are two things that this group of amendments actually seeks to introduce into the bill. And I commend the noble Lord German for introducing it so clearly, and indeed the noble Lord Faulkner for his excellent assistance in presenting the argument. And I think it's a statement of the obvious that Parliament, as your Lordship's House certainly, as we voted on the Rwanda Treaty, what the bill states is not common sense, it's not based on the evidence, it is being disproved. But more than that, what this is saying is that there is a person being held responsible for making a judgment, which is the Secretary of State is, by these amendments, made responsible for making the judgment. And surely if we are going to have a rule of law, that has to be a person who's there going to be held responsible for making a judgment, a person identified as making that judgment. We're introducing a sense of responsibility here and a sense of evidence. And that would be a step forward, at least.
My Lords, I raise just briefly to support my noble friend, Lord German. It's been a short debate in comparison with the first group. I think that's presumably because of those who had their second reading speeches all done in the first group, and then now that's sufficient for them in the bill. So we'll just have to go through the grind. But nevertheless, interesting. And I want to pick up on the point that noble Lord Howard had mentioned. Now, of course, the members of the Supreme Court are not here to answer questions. But my understanding was that the Supreme Court considered whether the Divisional Court was correct in deciding whether ministers had carried out the incorrect process under law. But the Supreme Court made the view that the question to answer was whether or not issues of fact with regards to refoulement as to the origin of this course for the appeal was then to be determined. So that is why the Supreme Court made the decision that it did. And that is the relevant part. His question about judicial review, so I don't think that the relevant part of judicial review is the Supreme Court's judgment. I think that the relevant part for judicial review in this bill is that judicial reviews can no longer, in future, be carried out on ministers' decision, on any decision makers for their decisions of sending anybody or relocating anybody to Rwanda. On process, that is now going to be prohibited. And that is, if I may say so, a very major constitutional step, something which the Bingham Centre have warned against, many others, and I suspect we will hear that in other groups in this bill. So for me, that is the important part of judicial review. But the noble Lord Murray, who's not in his place, even though he spoke in the group, listening to the closing speeches of the minister, or is he? Maybe he's moved. I don't know. No, I don't see him. He referenced the Supreme Court in an intervention to my noble friend with regard to when the Supreme Court made its decision and whether that decision made could only be taken as a snapshot view of the position of Rwanda then. Because that seems to be what the ministers have said. The Minister, Lord Stewart, the Advocate General, said it at second reading. The Minister referred to it in the first part. This seems to be a fundamental part of the Minister's case, that we can only look at the Supreme Court judgment in the context of the evidence that it took and the information that it took up to the point of its judgment. But we know, as my noble friend said, paragraph 104 of the Supreme Court judgment said categorically and very clearly that, I quote, "The necessary changes may not be straightforward as they require an appreciation that the current approach is inadequate, a change of attitudes and effective training and monitoring." In paragraph 102 of its judgment, the scale of the changes in procedure, understanding and culture which are required. So the scale of the changes as attitudes, effective training and the current approach. But there has not been, as we know from the UNHCR report this January, that the UNHCR, which the Supreme Court gave considerable weight to, all of those factors are not in place still. And that was a major reason why this House declined to state that currently we are able to say that Rwanda is a safe country. So the Minister's case, if he is, when he's winding this group, if he is to persuade us that the Supreme Court's view should now, to some extent, be addressed because of the time lapse, it has to be evidenced what has happened between then and now. And that is what my noble friend is asking of the Minister, and I hope he's able to give a very clear, detailed response with regards to Amendment 84. Because what Amendment 84 does is lay out the 10 areas which had been identified by a committee of this House, which have, of those areas relating to what needs to be done before we might consider if Rwanda is a safe country. And at this point I want to raise the challenge that I've got about the we here. Because the we here is Parliament, not the executive. The legislature, not the executive. And making a determination about a relocation, or indeed of a safe country. Now, we know that it's been fairly long practice for there to be lists of countries of which someone could be relocated to. It's either because we have a relocation or resettlement agreement, it's where the ministers have stated in secondary legislation, of which subsequently has either not been vetoed or been approved by Parliament, that an individual may be sent back to. Sometimes that's under a voluntary scheme, or that could be a forced removal. That is a long-standing practice. It's hard, it's difficult, it's controversial, but there's consensus that we have that approach. That is a world away. A system where you have an executive stating that they would consider a country to be safe, approved by Parliament, and then can be judicially reviewed. We are now a world away from that when it comes to uniquely one country of Rwanda. Uniquely. It's kind of a reverse Keynes, isn't it? If the facts change, I change my mind. What do you do, sir? Well, it seems as if ministers have changed their mind, so they want to change the facts. So what are we going to do now? Well, I don't think we should approve it, because we will now be, on the statute book, unique amongst our legislation to have legislated in perpetuity in a primary legislation that are defining a country's asylum procedures in accordance with our standards. That if they change them in any way, we would have to change statute in this country to follow what they do. Of course I'll give way to the Noble Vice.
I know I'm going slightly outside the ordering of clauses, but if you would look at Amendments 81 and 82 to Clause 9, that addresses this very difficulty which the Noble Lord has identified. Circumstances can and almost certainly will change. What we need to put in place is rolling sunsets. So this bill is never in force for more than, say, 2 years. And at each time that it is extended, there is a proper assessment of the safety of Rwanda, its compliance with treaties, and incidentally, whether the policy itself is succeeding.
I'm grateful for the Noble Viscount, and I listened carefully to what he said, and including at second reading, and when he comes to make the case, I'll also listen very carefully for that. If he forgives me for saying so, we will be into the kind of the categories of Plan C, D, E, and F to try and make this bill a bit better. I think this is referred to the Noble Lord Kerr in the first group. These are all silk purse amendments, aren't they? We are desperately trying to make something that we, in our hearts, know can't be better. We're trying to just take the rough edges off it slightly. Our approach in this group is to revert this bill to long-standing common practice for asylum laws. Laws which regular ministers on those benches have said is the proper procedure, because it includes executive decision-making, parliamentary approval, and then judicial review. That is what we seek, that is what we are saying should be the case, because that's what ministers have said for us for years is the case. And that's what we're seeking to restore. The mechanism and the reason why 84 is amendment is because it requires ministers to report on these areas. I wrote to the Foreign Secretary in December asking a whole series of questions regards to the treaty. The Minister, Lord Sharp, gave me the courtesy of a very substantive reply, and I'm very grateful for it. I asked questions specifically about when some of the mechanisms of the treaty would be in operation. For example, on capacity with regards to the decision-making processes in Rwanda for us to determine whether or not they would have the capacity and it would therefore be able to be safe. The Minister replied, I quote, some of the newer mechanisms will be finalised before operationalisation. So I want to know when. The government clearly is working on it. They must have a working assumption of when they're going to be the place. So tell us, because if the government's saying, we are the determining body, tell us when those procedures will be in place. Because the government can't have it both ways. They can't say that we are the determining body, but they have the information. That doesn't cut it anymore. If we're the determining body, we have to have the information. It's why I asked about when the judges will be in place, because under the treaty there will be judges who are not Rwandan nationals who will have to be trained on Rwandan law, not UK, Rwandan law, because the Noble Lord Horam, he's not in his place. He was completely wrong in the first group about this being similar to the Australian processes. These people who are going to be relocated will be processed under Rwandan law, not under British law. So the judges will have to be trained on it. Non-Rwandan judges will be trained on it under the treaty. So I asked when that would be complete, because obviously we're not going to relocate an individual where there would be a panel of judges who are not trained sufficiently on Rwandan law to process them. Now, I'm sure everybody would agree with that. The Minister replied to me, the proper procedures, facilities and support for relocated individuals with regards to the judges' training will be in place before they are relocated to Rwanda. Will be in place before relocations. But the Prime Minister, obviously, when he bet with Piers Morgan that the flights would be leaving, he obviously knows when the judges will be trained. So when will they be trained? What is the working assumption of when they'll be trained? I'm desperately trying to not make this a complete silk purse exercise. The final thing I would say, where we fully are in Alice in Wonderland situation, the Minister in the earlier group said, because things have changed, we now should look at the new country note. So the new country policy and information note, version 2, and now version 2.1 in January, that's what he was referring to. That supersedes the summer of 2022 country note. So the Minister is saying that old note shouldn't be taken into consideration because there's a new note. And if we wanted to refer to what the position of the UNHCR was, up to date, then we should, as the Minister said in the first group, we heard him, we need to look at Annex 2 of that report. Not only have I read front to end the country policy notes, I also clicked on the links in the policy note of Annex 2. Anybody can do it now on their smartphones. Click on the link. What comes up is a box saying this publication was withdrawn on the 11th of December 2023. The publication that the Minister referred to, which was withdrawn, was from May 2022, which the Supreme Court used as its evidence for UNHCR. So how on earth, if we are going to be the decision-making body, going to be making decisions when the government doesn't tell us even the basic information of when it thinks Rwanda will be a safe country, not us?
Yeah.
My Lords, as the Noble Lord German said, there is a suite of amendments here in this group which in many ways is covering the same ground as in Group 1. And it's clear from this short debate as well as the Group 1 debate that the House and the committee wishes to approach this bill by ensuring that the terms of the treaty are being properly adhered to, and essentially we're debating that mechanism. This debate on how best to do this will dominate really the whole of committee stage, and I hope that colleagues can work together to return the best possible solution on this issue. My Lords, for the opposition, in the same way that we would not wish to delay the passage of this bill, we would not want to create barriers for the scheme to start. Our focus should be on how we monitor and judge the safety of Rwanda, who monitors it, and what should happen if Rwanda is judged not to be a safe country for those being removed to it. The Noble Lord German, on introducing his amendments, his amendments 4 and 17 said that there shouldn't be commencement of the Act until Rwanda is deemed a safe country, and then he spoke at, a number of Noble Lords have spoken at length to Amendment 84(1)(c), which are the 10 issues raised by the committee of this House about how that might be achieved. And as the Noble Lord said, he was really looking at how that might be done, how many of those elements are in place, which are operational, and perhaps more fundamentally, whether Rwanda has the practical ability to fulfill the undertakings on a more long-term, in a more long-term way. And that's really the point which the Noble Lord Inglewood made on his brief brief contribution to this group. My noble friend Lord Faulkner speculated that the Secretary of State could, after making a decision, could be open to judicial review. And the noble Lord Howard said that the Supreme Court didn't use the principles of judicial review when it made its decision, but decided to decide the case on first principles. Now, my lords, both noble lords are well above my grade in legal matters, but it did seem to me that this may be another example of possible compromise as we move forward, as there were possible areas of compromise discussed within Group 1. My lords, the noble Lord Purvis of Tweed gave his customarily extremely articulate speech on the various provisions within Amendment 84(1)(c), and to use his phrase, he spoke of making a silk purse out of a sow's ear, and went through various ways that might be achieved, although he made his reluctance to do that very clear. And the noble Viscount Lord Helsham spoke about his amendments 82 and 84, which we're getting to in a subsequent group. Okay. 81? 81 and 82, I beg his pardon, on the rolling sunsets as he described them. And so really, this whole group is trying to make sure the government is properly held to account. As I said in my introduction, our focus will be on how to monitor and judge the safety of Rwanda, who monitors it, what Parliament's role is in that, rather than putting up a barrier against the bill itself.
My Lords, I'm grateful to all noble lords who've contributed to this debate, in particular to Lord German for opening, and I acknowledge the spirit across the House of approaching this matter as a matter of looking to see what can be amended and not setting out to wreck the bill, as indeed Baroness Chakrabarti said in opening in Group 1.
Let me intervene for a moment. I would like to wreck the bill, just so you know.
I do accept, and I did hear the noble lady make that point from the benches opposite. My Lord, since summer 2022, when judicial review proceedings in relation to the Migration and Economic Development Partnership began, the United Kingdom and the government of Rwanda have worked to refine and improve that partnership. And this has not only strengthened the operational readiness of Rwanda to receive and support migrants relocated under the partnership, but also the legal footing of the agreement and the commitments both sides undertake to ensure national and international obligations and standards are met, having scrutinised closely and carefully all the circumstances of the country and information from appropriate sources. Rwanda has a long history of supporting and integrating asylum seekers and refugees in the region. It's also been recognised internationally for its general safety and stability, strong government, low corruption, and gender equality. My Lords, I quote from the Kigali-based Comprehensive Refugee Response Officer, Diana Bose, of the UNHCR, when she said in December 2021, my Lords, mark the date, Rwanda has done an excellent job integrating refugees into the national education system, including urban refugees in the National Community-Based Health Insurance Plan, providing them with national ID cards and offering them livelihood opportunities. My Lords, as the committee is aware, the bill is a matter which is underpinned by the treaty, and Article 10 of the treaty in particular sets out the assurances for the treatment of relocated individuals in Rwanda, including abiding by the Refugee Convention in relation to those seeking asylum. Furthermore, pursuant to Article 3 of the treaty, the parties agree that the obligations therein shall be met in respect of all relocated individuals, regardless of their nationality and without discrimination. Under this commitment, Rwanda will treat all groups of people fairly. We have assurances from the government of Rwanda that implementation of measures within the treaty will be expedited. The treaty will follow the usual process with regards to scrutiny and ratification, and I note amendments tabled by noble lords on this topic are to be debated in the group to follow. My Lords, Amendment 17 would also oblige the Secretary of State to consider only consider Rwanda safe if it was deemed so for every descriptor of person as set out in Section 3 of the Illegal Migration Act. On relocating individuals to Rwanda, decision makers will make a case-by-case decision about whether there is compelling evidence that the particular circumstances of each case would mean that an individual would be at risk of serious and irreversible harm were they to be relocated to Rwanda. My Lords, this means that each person's circumstances are considered before relocation, and we consider, therefore, that this amendment is unnecessary. Amendments 24 and 27 are in relation to the roles of courts and tribunals. It is important that we recognise that these are considered decision makers in relation to relocating individuals to Rwanda, and they may have a say in this. Amendment 27, in particular, would place an obligation on courts and tribunals to consider any claim that Rwanda may breach its international obligations by removing an individual to a country that was unsafe for them, to consider any claim that an individual may not receive fair and proper consideration of their asylum claim, and that Rwanda will not act in accordance with the terms of the treaty. My Lords, this obligation is unnecessary. Rwanda is as committed to this partnership as we are. We've worked closely together to build this partnership and have trust that the commitments in the treaty will be upheld. And that is why we have introduced this bill, which reflects the strength of the government of Rwanda's protections and commitments given in the treaty, allowing Parliament to confirm the status of the Republic of Rwanda as a safe third country. Now, the noble and learned Lord Falconer of Thoroton, in his intervention, and I speak to his later intervention rather than when he was assisting the noble Lord German with legal analysis and intervening, he referred to the possibility of judicial review and posed the question of whether that might be applicable, a point which my noble and learned friend Lord Howard of Limney took up as well. Now, my Lords, in relation to that aspect of matters, I'd refer the noble Lords to the terms of Article 22 of the treaty, which provides that in the event of a dispute arising out of or relating to this agreement, including any question regarding its existence, validity, termination, interpretation or implementation, the parties shall refer the dispute to the Joint Committee, which shall meet within 14 working days to discuss and seek resolution of the dispute by consultation. Now, my Lords, therefore the process by which matters will be addressed if there is some shock to the operation of the system once it is operational, is set out in terms of the treaty and therefore operates on the level between the two countries.
To the noble and learned lord for answering the question. I'm not sure that does answer the point. Suppose the position were that the UK was saying you haven't implemented it properly. The effect of this act would be nevertheless the minister and every single deciding body would have to decide that Rwanda was a safe country. So I'm not quite sure how Article 22 responds to the suggestion that I think the noble Lord German is making in his amendment, that judicial review should be available, albeit, as the noble Lord Howard Olymp said, it would be the decision of the Secretary of State as to whether or not it was a safe country. So could the noble Lord address that suggestion?
Yes, my Lords, in relation to the operation of the treaty during its currency then, we have to bear in mind that there is in place a monitoring committee which examines these things on a going forward basis and keeps them under supervision and reports back. My Lords, in preparation for the, I do beg your Lordship's pardon, I'm taking matters out of their natural order. My Lords, Annex B of the treaty also sets out that the claims process for relocated individuals and how they will be treated. It sets out clearly that members of the first instance body who will make decisions on asylum and humanitarian protection claims shall make such decisions impartially, solely on the basis of evidence before them and by reference to the provisions and principles of the Refugee Convention and humanitarian protection law. My Lords, in preparation for the potential relocation of individuals, officials in the United Kingdom have worked together with Rwandan officials to develop and commence operational training for Rwandan asylum decision makers. Most recently, Home Office technical experts, in collaboration with the Institute of Legal Practice and Development, delivered a training course aimed at asylum decision makers in Rwanda.
Might tell us how long the course was for and how many people were training and where they were from?
Well, the noble Lord won't be especially surprised, I think, to hear that I haven't got those facts to hand. But I will undertake on behalf of the relevant department to communicate with him in writing on that topic. My Lords, the course focused on applying refugee law in asylum interviews and decision making.
The UN has reported on the treaty and the deficiencies that the Supreme Court gave, and in January of this year noted in paragraph 19 of its report on the issue that training in itself, based on its historical view of what's required in such circumstances, normally is of limited use. Could I ask the noble Lord the Minister, over and above the training, what else has been put in place for these decision makers to ensure that they fully abide and understand their obligations, not just within Rwandan law, but also international agreements?
Well, Lords, as I said when I was responding to a point taken by the noble Lord Falconer of Thoroton, the presence of British officials in Rwanda, the presence of foreign judges in Rwanda looking at these matters and working collaboratively to resolve them will clearly inculcate an atmosphere, will inculcate a spirit of their proper observance.
The noble Lord speaks in the future tense. The presence of British judges will have that effect. The training will have that effect. And I guess he's right. It may very well have that effect. But the point is we are asked to declare Rwanda safe now. I hope the noble Lord is going to answer Lord Purvis's questions about timing. When do we expect Rwanda to produce the new asylum law? When do we expect the judges to be appointed? When do we expect the system that is to be devised to ensure that there is no refoulement. When is that system going to be created? When are the government going to see it? When is the House going to see it? If we're asked to say that Rwanda is safe, then we have already voted that we cannot ratify the treaty until the measures that were set out in Amendment 84, that were in the International Agreements Committee report, have come into effect. So it's all very well the Minister speaking in the future tense. He has to tell us now when things are going to happen.
My Lords, I could intervene. I may have missed it, but I wonder whether the noble Lord, the Minister, could say whether Rwanda has drafted a refugee law.
This list, as the noble Lord set out, of the number of judges who have agreed to go to Rwanda and work there, and indeed of the number of officials and for how long.
My Lords, it's a matter of working towards having these safeguards in place, and we have received assurances from the government of Rwanda that the implementation of all measures in the treaty will be expedited. The point being, my Lords, that we are working with them to accomplish that end. We have already developed and commenced operational training.
I wonder if, I'm grateful for the Minister. That's the closest we've got to an answer, working towards. So can we just pursue that just a wee bit more? If Rwandan government is working towards putting safeguards in place, that means that they are not currently in place. Is that correct?
Well, it must do, my Lords. And in just before the noble Lord sits down, so before the noble Lord stands up or resumes his seat, resumes his position, I do have specific information on the point which he raised earlier on about information available electronically. I'm told that the page to which the noble Lord on the Gov UK site was referring was in fact withdrawn on the 11th September 2023, and that it has been superseded by one which is dated the 11th of January 2024 this year.
Well, I'm grateful. I clicked on it half an hour ago, so the box, maybe they can do some clicking in the box, because it doesn't, because the information he just provided to is false. So he does need to correct the record, but he can do it in writing to me if he so wishes.
I think a discussion on this point would be taking up too much of the committee's time.
So the question is, as the Minister had confirmed to me, that by definition the safeguards are not in place that would make Rwanda safe, because the Rwandan government is working towards having them in place. Then why has he asked us to determine that Rwanda is currently safe when the Minister said it is not currently safe?
Question is the noble and learned Lord not embarrassed by the word "is" in that clause, which is I'm going to address in the next group. It's the language of that particular provision that causes embarrassment to the government, and they really do need to face up to the significance of using the word "is."
My Lords, I think that brings us, taking the noble Lord Purvis of Tweed's contribution together with the noble and learned Lord Hooper Craig Head's contribution, into considering where we are with the decision of the Supreme Court and how that sits with what we are as a government inviting the House to do at this stage. My Lords, the point is that, and it's one which has been anticipated by noble Lords contributing in this and I think on the previous group, that the factual basis upon which the Supreme Court reached its decision has changed. The factual basis upon which the Supreme Court reached its decision was the one which was frozen in time, as it were, by the Court of First Instance. And since then, considerable development has taken place. The facts have changed. We are entitled, my Lords, to move forward. Nor do I consider, my Lords, that there is anything...
Lord, give way. The UN, in January of this year, has given an assessment of where the Rwanda immigration system is. And paragraph 18 of that report says, as of January 2025, the UNHCR has not observed changes in the practice of asylum adjudication that would overcome not only the concerns of its 2022 analysis and in the detailed evidence presented to the Supreme Court. So what the UNHCR is saying is that as of January of this year, they have seen no evidence that the issues that the Supreme Court had in its evidence has been addressed to make Rwanda a safe country.
Well, my lords, we disagree with the views of the UNHCR on that point. The UNHCR, as noble lords were reminded at an earlier stage in the previous division, are not the sovereign parliament of this country.
A moment ago said that Rwanda is working towards. That is not the same as is. So I hate to say it, but it would appear that he is contradicting himself.
I don't think that's the case, my lord. I think that by saying that Rwanda is continuing to work in a process is to say that it is working on making things safer, not to say that they are not safe already.
Interrupt, but I just want to ask this. It's just that we haven't received any evidence as to how this change has taken place in this short period of time. What evidence is being placed before this House to show that there, rather than an assertion, what evidence is being placed before this House as to what is taking place and what has taken place to totally change the assessment of safety into... I really would like to hear what the evidence is.
Could I just, to assist the noble and learned lord in relation to this, there's a document called Safety of Rwanda, Asylum and Immigration Bill. And what this rather excellent document reveals is, I think, and no doubt the noble and learned lord will correct me if I'm wrong, since the Supreme Court decided there's the agreement that's been entered into, which is really just making, as it were, legal and international law commitments they'd already given. And just before the Supreme Court gave its judgment, there were two courses that were held. One from the 18th to the 22nd of September 2023, and the second from the 20th to the 24th of November 2023, in which a number of Rwandan officials attended a course, training them, as this document says, to have a better understanding of the Refugee Convention. Now, apart from those two courses and the entering into of the agreement that you've referred to, could the noble and learned lord tell us what else has happened since the rendering of the judgment of the Supreme Court, which I think was a few weeks ago?
Not more than a few weeks ago, I think, my lords, but what we have is an internationally binding treaty between two sovereign states. That, if the noble lord will bear with me, that is a matter of the utmost significance in considering such matters.
In saying that the legally binding commitment commits them to do the things, in particular in relation to refoulement, which they had already promised, though not in an agreement, to do. And am I right in saying that the very judgment that Lord Sharp said to us an hour ago, the government respects, said it would take a considerable time to give effect because of the cultural understanding and the need for very substantial change? And I am looking for something other than simply signing an agreement to do with that which they'd already promised to do, which the Supreme Court said they weren't in a practical position to deliver. So tell this House, if you would, what, if the Minister would, I apologise for calling him you, could the Minister tell us what's happened which gives one confidence that that which the Supreme Court says would take time will in fact be ready in an instant?
It's not a matter of being ready in an instant, my lord. The work is, my lords, the work is being undertaken. The point is that we have a specific treaty commitment not to refool, not to, in other words, as the noble and learned lord knows, and just to remind the whole House, not to send people from Rwanda anywhere other than back to the United Kingdom, and specifically not to send them to places where they might be subject to torture or inhuman treatment, and specifically, again, further, not to send them back to the countries from which they emerged if those countries are deemed dangerous.
It is the position that we have bought through financial consideration a special treatment for the people that we send for asylum as distinct from anyone else who's been considered for asylum, or is the asylum system as a whole being reformed? Because if we're buying them business class as distinct from sitting at the back of the bus, then is that something that really conforms to our high standards of the rule of law and the protection of human rights? Or are we just buying something a bit special for the folk that we're intending to put on a plane?
My Lords, the government enters into diplomatic arrangements such as treaties with another country. We do so on behalf of the government of the United Kingdom. We do so on behalf of the people, the country of the United Kingdom. Decisions as to how to approach handling migration or immigration or asylum claims elsewhere are surely matters for other countries. We would not trespass upon their independence and privileges in order to negotiate on behalf of them with a separate sovereign country.
To be reformed in order that we can be confident of the quality of decision making.
I think the noble lady has my answer, but the point is this: we do not impose or seek to impose upon anyone. Nor when the noble lady talks about buying a privileged status would I go along with that. What I'm talking about, and what the government is seeking to enact in this measure, is a commitment with a forward-looking, democratic country which is signatory to the same treaties and the same international obligations which we are.
Would my noble friend give way?
Sorry, to my noble friend, the noble lady, Lady Lister, is about to stand up to intervene. I'm aware she hasn't been in for the whole of this debate. Okay.
I'm sorry to intervene again, but I have been here the whole debate. May I take him back to the noble Lord Scriven, who quoted from the UNHCR, and the noble Lord the Minister said, well, we don't agree with the UNHCR. But the UNHCR does point out that its conclusions are based on, quote, its own extensive experience in capacity development of national asylum systems. Is the noble Lord saying that this government has more experience than the UNHCR in terms of the capacity of countries to change? And it makes very clear that training isn't enough. It's all about, it needs to be systemic change and change its culture.
As I say, my Lords, this is now a matter of a treaty commitment by that country. And we do accept the possibility, surely, that countries have changed. We know the trauma which Rwanda has gone through in the comparatively recent future, and we support and acknowledge the work that they are attempting to do as part of a forward-looking African country, looking, as it were, to provide solutions as opposed to exporting problems. The noble Lord Howard.
To my neighbour friend for giving way, these questions have ranged far and wide, but is it not the case that the one issue, as I understand it, on which the Supreme Court came to its decision was the risk of refoulement? And that is covered in the treaty, and anybody would be able to see and know whether anyone was refouled in breach of international law and in breach of the concern expressed by the Supreme Court.
I'm grateful to the noble Lord because, of course, the matter is entirely patent on the Supreme Court's decision. It is about refoulement. We now have a treaty commitment preventing that from happening.
A straightforward and more simple question for the noble Lord the Minister. In paragraph 20 of the policy statement, it says, in order to implement the treaty, the government of Rwanda will pass a new Rwandan asylum law in the coming months. When will that law be produced? And has it already been passed? And when will it be passed? Because if it's going to be after that we pass this act, as an act, then this obviously can't be, the treaty can't be enabled.
Lords, I don't have information specific to the questions which the Noble Lord raises.
Before the Noble Lord sits down, I've listened very carefully to this debate, and I was particularly interested in the comments from my noble and learned friend Lord Faulkner about the training of people in Rwanda, and he said, I believe I got it right, that there were 2 weeks of training. Now, any treaty to work must be between countries of equal. And my impression is that we are telling the Rwandan government people what to do, putting pens into their hands and making them sign without properly training them and giving them the experience to act equally to what we're looking to do ourselves. I may be wrong, but maybe the Minister can put me right.
Well, I do think that the Noble Lord overstates the matter. Advice and assistance is being provided to assist a country to shape its laws and its culture in a way which is consistent with ours. My Lords, the work which Rwanda has undertaken is substantial, and work has been done in response to the decision of the Supreme Court, albeit, as the Noble Lord, Lord Howard, Noble and Learned Lord, Lord Howard of Limney points out, that decision ultimately related to refoulement, which is a matter expressly covered in the treaty.
Again, for interrupting, the Noble and Learned Lord, the Noble Lord, Lord Howard, is correct when he says that the fundamental reason the Supreme Court said no to this was because of the risk of refoulement. But they said the risk of refoulement was caused by the totally defective system right across the board in relation to their asylum system. They couldn't prevent refoulement because their system was so bad. And I quote from the judgment, its practical ability to fulfil its assurances, at least in the short term, in the light of the present deficiencies of the Rwandan asylum system, the past and continuing practice of refoulement, and the scale of the changes in procedure, understanding and culture which are required is what it identified as being required. And so it is a both accurate but rather misleading statement to say it was only refoulement. There was the risk of refoulement because of the failures. Would that be the government's understanding of the position?
People cannot be refooled to a different country under this treaty. They can be sent back to the United Kingdom. They can be sent back to the United Kingdom, and that is as far as it goes.
Will the Noble Lord give way? The Noble Lord, the Minister, rests a great deal on a signature of a treaty with a country that, with this government, has in the last decade refooled over 4% to Rwanda. So that was this government of Rwanda behaving badly with refoulement. Why are you so confident that the same government is so fundamentally different and reformed?
Well, my lords, the treaty is governed by our laws, by the government of Rwanda, and by international law. The Noble Lord, for a diplomat, seems to have, for a former diplomat, seems to have very, very little confidence in the ability of treaties to regulate the conduct of governments between one another. Of course.
Very generous. I just want to pursue, if the Minister was to be persuasive in response to that question, he wouldn't have said that they are working towards putting safeguards in place, which have to be in place in order for the point for refoulement for the Noble Lord Howard said. And that's what the Minister said. The Minister said working towards putting safeguards in place, of which the Minister, Lord Sharp, had said that no relocation will take place before these safeguards are in place. So at the dispatch box, can the Minister reconfirm that position? No individual will be relocated before the safeguards are in place, which includes the appeals mechanism, the training, the capacity building. And when will that date be for when relocations of an individual can happen? Because we will be informed in Parliament that all of those safeguards are in place. Not that they will be in place, not that they're working towards, but will be in place.
Well, Lords, I can answer the first part of the Noble Lord's question in the affirmative. The second part, I cannot give a date.
Would my noble friend give way? As I understand it, my noble learned friend is effectively saying that because the treaty is going to be in place, Rwanda can be presumed to rely on its obligations. But may I just point out that if we look at this bill and its section 1.4, it says in terms, it is recognised that the Parliament of the United Kingdom is sovereign and the validity of an act is unaffected by international law. International law is very widely defined in subsection 6. If that is true of this country, is it not also true of Rwanda? And why should we necessarily believe on their commitments to that treaty?
Another noble lord who is too ready, perhaps, to disparage the activities and the views of the Rwandan government. My lords, as to the first point, I quote from the Constitution Committee's report at paragraph 54, which was the report which was published recently and which was quoted earlier, I think, by the noble Lord, Lord Jermyn, towards the beginning of this debate. It is the case that the United Kingdom Parliament is sovereign and therefore may enact legislation which breaches international law. It is also true that the validity of an act of Parliament in domestic law is not affected by international law. Nevertheless, the United Kingdom is still subject to the provisions of international law. My lords, I don't disagree with anything that the Constitution Committee says in that document. The United Kingdom and this government takes its international commitments extremely seriously. But this measure, this treaty and this bill are drawn up in response to a considerable problem. People are dying and a huge amount of money is being spent by the United Kingdom in accommodating people, and many of whom have no business being here in the first place. This bill is an attempt to drive the matter forward. As the noble Lord Lord Coker said in winding up for the opposition front bench in the course of the second reading debate, there are a number of things that are being done already. He endorsed them on behalf of his party. He spoke about the directions against criminal law, against criminal groups in order to try to break their business model. He spoke about the enhanced levels of cooperation with our partners on the continent of Europe. But patently, while this is a complex and multi-layered problem, these things are not working of themselves. And the government has taken the view that we must take further measures to try to stop the boats.
I do think that the noble Lord, Lord Howard, is quite right that the crux of the Supreme Court judgment is the question of refoulement. Ex-diplomats tend to take treaties very seriously, and indeed they read them. Article 10.3 of the Treaty with Rwanda says the parties shall cooperate to agree an effective system for ensuring that refoulement does not occur. The parties shall cooperate to agree an effective system. That's the crux of it. Where is that system? Can we see that system? If we could see that system, it might help us to determine whether Rwanda is safe.
The noble Lord is aware that the provisions of the treaty, as I explained a moment ago, will send people to the United Kingdom only. They will not and cannot be refoulement under the treaty and under the arrangements that we have with Rwanda.
Right. Why then does Article 10.3, second sentence, exist? Why is it there? Why is there to be the parties shall cooperate to agree an effective system that removal, for ensuring that removal, contrary to the obligation which the noble learned minister refers to, does not occur? Why do we need a system? If the minister is completely confident, why has his government signed a treaty which has a fallback to say what should happen if refoulement does occur? And when will we see that system, which is to ensure that the fallback, the safety net, when are we going to see that? It's not good enough for the minister to say refoulement can't happen because we've signed the treaty. You've also signed a treaty containing a provision for what happens if refoulement nevertheless occurs.
My Lords, I think it's entirely prudent and appropriate to anticipate contingencies in the terms of a document such as a treaty.
Very grateful to the noble and learned Lord. He's taking a much tighter position and a much more defensive position than the government itself is taking. They accept the proposition of the noble Lord Kerr's question. They don't say Article 10 is enough on its own. They say the following: the Supreme Court concluded that changes needed to be made to Rwanda's asylum procedures in order to ensure compliance with the principle of non-refoulement. They accept the proposition. That's paragraph 76 of the government's own statement. So tell us what changes and where we've got to. It's not enough, because the government accepts it's not enough just to rely on Article 10.
My Lords, I've adverted at some length already to the monitoring committee which is there, to the work which is currently underway by Judicial and by bureaucratic, by civil servant staff assisting the Rwandans in working through these matters. My Lords.
I'm feeling slightly confused at this point, but am I correct in saying that the government accepts that at present Rwanda has not fully adhered to the commitments it's given, and therefore it follows that it would be, by reference to those tests, unsafe? But, as I understand it, even if the government did nothing, when this particular bill, if it goes on the statute book as currently drafted, no changes will take place in the wider world, and suddenly it becomes a safe country. Is that the reality of what we're looking at?
My Lords, the intention of the bill is to provide that Rwanda is a safe country. As I've explained to the noble Lord Faulkner of Thoroton in discussion of Article 22 of the treaty, in the event of some disturbance to that situation, the matter will be approached on the government-to-government basis or by the convening of the relevant committee within 14 days. My Lords, returning to a text which was prepared earlier for me, the committee might bear in mind that Article 10 of the treaty in particular sets out assurances for the treatment of relocated individuals in Rwanda, including ability by the Refugee Convention, including abiding by the Refugee Convention in relation to those seeking asylum. Furthermore, pursuant to Article 3 of the treaty, the parties agree that the obligations therein shall be met in respect of all relocated individuals, regardless of their nationality and without discrimination. Under this commitment, Rwanda will treat all groups of people fairly. Furthermore, my Lords, Article 10.3 in the United Kingdom Rwanda Treaty sets out clearly that the only place, we've covered this ad longam, to which Rwanda can remove individuals is to the United Kingdom, and that ensures that there is no risk of refoulement. For noble lords who remain concerned as to whether the treaty will be followed, will be abided by the Rwandan government, the independent monitoring committee will be in place to ensure that obligations in the treaty are adhered to. For an initial period of at least 3 months, there will be enhanced monitoring, where monitoring shall take place daily to ensure rapid identification of and response to any shortcomings, and I refer the committee in that regard to Article 15.7 of the treaty. My Lords, this enhanced phase will ensure that monitoring and reporting takes place in real time. Individuals who are relocated to Rwanda will be able to raise any issues of concern should they arise with the committee. It should also be remembered, as I've said on a number of occasions already, that this is a legally binding treaty that will become part of Rwandan domestic law. My Lords, taking all of this into consideration, I submit that these amendments are unnecessary. Further, they undermine the objective of the bill, unnecessarily delaying, potentially, the relocation of individuals to Rwanda. And I therefore ask the Noble Lord to withdraw his amendment.
Before the Noble Lord Minister sits down, if the committee will forgive me, slid into an earlier part of the Noble Lord's response was a reference to some glowing statements about the progress within Rwanda of gender equality. And I think those are statements that should not be allowed to just left stand, because although we have been very much focused in this debate on the issue of reform, we're assuming that if people, refugees, in particular women refugees, are given status in Rwanda and they remain in Rwanda, they will have to live in Rwanda. And making glowing statements about gender equality in Rwanda, now I think it's very well known that, yes, in terms of parliamentary representations, ministerial representation, Rwanda has made very considerable progress, indeed more progress than our own parliament has. But nonetheless, I don't know if the Noble Lord the Minister is aware that in Rwanda, 83% of women work in the informal sector or in low-wage occupations, earning on average 60% of men's incomes. And the 2021 National Gender Statistic Report revealed that physical violence affects 36.7% of women and girls aged between 15 and 49 in Rwanda. So I just wonder if the Noble Lord the Minister would acknowledge, with regard to his earlier remarks, that making claims about gender equality progress in Rwanda needs to be done with caution.
Well, I think it is, respectfully agree with the Noble Lady, that it is important to look at such matters with caution. And I would say that in relation to the figures which she cites, the statistics concerning domestic violence would be primarily, one presumes, a matter for Rwandan society itself, as opposed to...
Those were not domestic figures, those were general violence against women and girls figures.
And the Noble Lady is very aware, and I'm aware of her campaigning work on the topic, that the bulk of violence visited upon women criminally is within the domestic setting.
Lord the Minister, given that, what's the basis for his assertion, which is also made in the Noble Lord Sharp's letter to peers about gender equality? Perhaps he could give us some references, because the Noble Lady has.
I have a feeling, with respect to the important point which the Noble Lady tables, that this is a matter dealt with in a later group. I don't have the figures to hand in front of me at the moment. If we do not touch upon that in a later group, with which I may not be concerned, and I haven't had a look at that, as a result of the division of labour on these benches, what I'll do is make sure that the point which the Noble Lady takes, which reflects the Noble Lady's original question, and that those figures are brought out either in the scope of the debate or are the subject of correspondence.
Find his place, just to help the Minister find his place, and to be helpful actually. This is clearly becoming a bone of contention between the government from bench and the House in terms of the progress that's been made. To help us before we get to report stage, could the Noble Minister write to Noble Lords who have taken part in this part of the debate to show the significant progress, and that's the word that the Noble Lord the Minister used, in terms of the significant progress that Rwanda has made to deal with the concerns of the Supreme Court. So we have some evidence before we get to report to see exactly the content of those significant reforms.
I'm happy to take up the Noble Lord's suggestion, and we will correspond with him and other Noble Lords who've participated in this debate. So, my Lords, I'd touched upon the role of the Independent Monitoring Committee. We've heard already about the presence of persons from out with Rwanda, offering their expertise and skills, bolstering the system that is that will rule in these situations. One point that the Noble Lady Baroness Bennett of Manor Castle made was in relation to the situation in Rwanda. And of course, the committee ought to bear in mind that it is not the intention of the government